Let's check there to see if we're still on camera view. I set the camera such that the panel will be here.
Okay.
I'm going to ask them to come up.
I'm just going to start and then I'm going to sit down and down.
Okay. But I mean the presenters, are they going to come?
I think so, yeah, yes.
Okay.
Okay, so I'm going to just stand here, okay? Yeah.
Let's present them. Can come this side.
Okay.
So let me give you we have everybody in the room? Yeah, we do. Okay. Then
Good afternoon, everyone. Good afternoon. Welcome to the Law School and the Mandela Institute. I hope that you are all well traveled and well rested, and that you're looking forward to your deliberations. You're most welcome. It is an honor and a privilege for me as the director of the Mandela Institute, which is based in the law school, to welcome all of you, our guests from the United Nations, from Europe, I understand, mainly Austria, I understand, and Germany. And well, there was a time when I don't know if the borders were very clear between Austria and Germany. Long time ago, though. And then, of course, scholars from all across our continent, I understand, east, west, and south. The topic is not in my area of speciality, but I have some interest in it. I think this question of how to reconcile investor rights with the needs and the interests of our peoples, our states, in our countries and our continent, is one of considerable interest. And of course, we are in a sort of inflection point, different ways perhaps of describing the current period in which the global system seems to be experiencing considerable strain, and certainly what we perhaps started to call globalization 30 years ago, is now being reassessed and being rethought. And so your deliberations are of considerable interest and importance. And I'm sure that you're going to have a very constructive and productive experience. Once again, it's my real pleasure and privilege to welcome you all. I've just been mentioning that we've been doing a lot of work with UNCITRAL in recent months, and this in some ways is just a continuation. And of course, I hope that this will just be part of a growing collaboration. Thank you very much and welcome.
So is there a way, I don't want to project.
Yes. No, he's fine. Yeah. Just ignore this. It's the Zoom recording.
Yes, that's fine. Okay, so thank you very much for inviting me to be here. My particular thanks to Martin, Emmanuel, and Jonathan for setting up this event. And also wanted to say thank you in advance because I'm looking forward to the discussions to those of you that have written papers that we're going to discuss this afternoon and tomorrow. I want to say, and I'm going to speak about the origins of the idea of multilateral investment court. And I want to start by saying that it was perhaps naive on our part, but we did not imagine when we started the works of the European Union, when we started the work on the multilateral investment court, we did not imagine the attention that the project would attract. I think it's worth thinking about. It took us a moment to realize this, but the UNCITRAL Working Group 3 that I'm sure will feature a lot in our discussions is the first instance, first time that there's been a true international and multilateral discussion on investment dispute settlement. ICSID, of course, as you all know, is a multilateral instrument, but it did not emerge from genuinely multilateral discussions. Bilateral investment treaties are by definition bilateral. And the OECD or the UNCTAD work on investment has been largely analytical, and it at certain moments has not been either of a multilateral nature. So it is, I think it's important that we keep in mind that UNCITRAL Working Group 3, as it progresses through its agenda, is the first multilateral rulemaking locus that we have had to look at the questions of investment dispute settlement. And therefore, it is, we think, extremely important that the process and the outcome is truly multilateral. This means that we need, and I think I'm the only UNCITRAL delegate, formal delegate at least in the room. Oh, sorry, I'm not the only one. There are two of us. But I think I can say this on behalf of all the UNCITRAL delegates, that we need the input of scholars and we need the input of actors from all regions and from all countries if we are to ensure that the outcomes of UNCITRAL Working Group 3 are truly multilateral, and importantly, that they are capable or subject to acceptance internationally. So it's extremely important for me as head of the EU delegation to UNCITRAL Working Group 3 to be here, to hear your voices and to discuss with you how these views can be brought into the discussions. So as the first speaker and in agreement with Martin, Emmanuel and Jonathan, I would like to set the stage, if I can, by talking about the origin of the idea of the multilateral investment court project. And to do that, I would like to take a step back to look at the international investment regime. So first, I would like to propose the main features of the investment regime. We think that thinking about those main features leads us, secondly, to thinking about what is the most appropriate form of dispute settlement for such a regime. And third, this leads me at least to conclude with a description of how the EU and its member states envisage a multilateral investment court being structured and to respond to what we view as the most appropriate forum, or form rather, of dispute settlement. So first, what are the main features of the investment regime? In its submissions to UNCITRAL, to Working Group 3, the EU enumerated the following features as being relevant for thinking about the dispute settlement function of the system. So in our view, it has a constitutional public administrative law component. So the obligations that are set down in investment treaties are intended to protect investors from certain forms of state conduct. So applying these obligations implies striking a balance between the right of government to exercise sovereign authority and the duty to protect individuals, which is typical of constitutional or administrative law determinations. It is a unidirectional system. The investor initiates the case against the state by accepting the standing offer to arbitrate. It is not a system where, at least as it's been conceived, that it works bidirectionally, so the state can also sue the investor. The state, of course, has jurisdiction over the investor in its domestic jurisdiction. There is, third, in our view, a vertical relationship. So disputes predominantly concern foreign investors bringing cases against host states that arise from a vertical regulatory relationship between those actors due to the fact that the investor enters into the host state territory and enters into its economic and legal order. And it has a repeat function. So the treaties are in principle in place for a considerable period of time, and they will potentially give rise to multiple disputes over that extended period of time. And this is something that we think, importantly, is to be distinguished from one-off contractual arrangements. There is, fifth, a determinacy component. And by that, I mean that the substantive obligations are, by definition, indeterminate in the sense that they set down general high-level standards intending to apply in different, multiple possible fact patterns, very much like constitutional law provisions that we're familiar with in our domestic system. And finally, we think the sixth feature is a predictability or consistency function. And that flows from some of these other elements. That given the general formulation of investment protection standards and being conscious of this repeat function nature of the regime, stakeholders, whether they be governments, whether they be investors, whether they be civil society, whether they be academics, they look at precedents in order to understand how obligations in the treaties are being or should be interpreted. And this, in the investment regime, this occurs both within the same treaty and across treaties, given the relatively high degree of homogeneity of the treaties. What this means is that the adjudicative role is key in elaborating and further refining the precise meaning of the substantive obligations. So if one accepts that these are the core features of the investment regime, and this is what at least the European Union and its member states have posited in the UNCITRAL discussions, one is faced with the question of, well, what is the most appropriate form of dispute settlement mechanism to deal with such a system? Is the current system, which relies upon ad hoc arbitration, best suited, or some other format better suited? I'm not going to surprise any of you by arguing that the current system is not best suited. And this is not to disparage the actors or institutions working in the current system. It is rather, and I think we need to keep this in mind, is the creators of the current system could not possibly know how the system would develop over time. They were simply not able to analyze this question because the system that they were looking at, or the treaties and contracts they were looking at, did not have the features that that I've just enumerated. They designed a dispute settlement system, in particular the exit dispute settlement system, without the knowledge that 50 or so years later, there would be 3,000 treaties, of which a very high number would use exit for dispute settlement. At the time of the exit convention being negotiated, there were only a handful of bilateral investment treaties, and these mostly used state to state rather than investor to state dispute settlement. There are elements, I think this is debated, but there are elements in the history of exit that would suggest that the creators thought that the main use of exit would not be treaty litigation, but rather investment contract litigation. So if that was the case, and the view that they took was that most disputes would be contract disputes, that would turn on the interpretation of those specific contracts, then consistency and predictability are far from being the most important and relevant considerations. Moreover, as a practical matter, with relatively few treaties and relatively few disputes, it would have made little sense from an administrative financial point of view to create a permanent body with fixed costs. We know from the historical work of Taylor St. John that in the 1950s and the 1960s, when the European continental, in particular, countries started to envisage investment treaties, they contemplated the idea of creating a permanent body to solve these disputes, but they rejected the idea at the time. But what is striking, I would submit, is that when we step back, we can see that the regimes that involve the characteristics that I've enumerated as specific to the investment regime normally use standing bodies for dispute settlement. One can think of many examples. The ones closest, I guess, the ones closest to me are the European Convention on Human Rights with the European Court of Human Rights, or the European Court of Justice, or the Court of Justice of the European Union. Both of these legal regimes are in many ways engaged in a very, very similar exercise to that of the investment regime, because they're balancing public action against international legal obligations and rights of individuals. At the domestic level, the legal regimes with similar characteristics to the investment regime are also typically provided with permanent bodies for adjudication. It is a recognizable feature of domestic legal systems throughout the world that constitutional, public, or administrative law disputes are dealt with by standing permanent courts with independent judges that are often positioned within a hierarchy that permits appellate review. This is not a new invention. Bentham, Hamilton, Voltaire argued 200-300 years ago that a move to a permanent, publicly funded judiciary was a necessary step to ensure good governance. And for those of you that are interested in the history of all of this, there's a very interesting paper produced by the OECD that examines how the thought and analysis of Voltaire, Bentham, Hamilton is still relevant today when thinking about the international investment regime. So the idea of a multilateral investment court is not new or innovative as such. It was an idea that was floated in the 1950s and 1960s. And it was an idea that reappeared, particularly in the academic literature in the 2000s, with the first increase in litigation under investment agreements. The European Union and its member states drew on these ideas in 2015 and 2016 when we engaged in a re-examination of EU and member state investment policy. That discussion was triggered by a public debate about the investment regime. In fact, in many ways, that public debate was the first real public debate about international investment policy that had taken place in the EU or in member states at any moment in time. And it is, I think, an illustration or a reminder that the regimes that we construct internationally must also have legitimacy and an understanding at domestic political levels, so that they can build support in that legitimacy. And this was the policy change that eventually led to UNCITRAL Working Group 3 starting its work on the reform of investor-state dispute settlement. When UNCITRAL offered to set up the multilateral discussions that I mentioned in my opening, in my initial remarks. Now, let me say a few words about what the EU and its member states are proposing. I think one thing to keep in mind is that we don't claim any particular originality for the ideas that we are putting forward. The international community, scholars like yourselves, we now have a great deal of experience in the construction of international courts, sometimes positive, sometimes negative. To the extent that the history of legal institutions is one of borrowing, adaptation, and gradual development, there's plenty for the negotiators in UNCITRAL Working Group 3 to borrow from, to adapt, and to develop. As you all know, the last 20 to 30 years have brought a great deal of experience and of analysis of how best to ensure the effectiveness of international courts. And as you also know, UNCITRAL Working Group 3 is accompanied by an academic forum, which has the objective to distill and disseminate the knowledge that is now available of how international courts function to the delegates of Working Group 3. Now, the EU has set out in a detailed submission to UNCITRAL Working Group 3 how a permanent court could function. And I think I would emphasize the could function. These are the ideas that the Union has put forward for discussion in the working group. Those key features that we would foresee for an international, a multilateral investment court would be as follows. So we would establish a permanent court that would function at, in our view, it should function at 2 levels. First instance, obviously the main locus for resolving a dispute and the possibility of an appeal. Adjudicators would be appointed on a full-time basis, so they should not have other activities to deal with, in particular, the pernicious issue of double hatting, which, for those of you that follow the working group in detail will know is one of the issues that the working group is struggling with, is having significant struggles with, I think is the diplomatic way of putting it, in elaborating code of conduct for ad hoc arbitrators. So our vision of this would be to do away with ad hoc arbitrators and appoint adjudicators on a full-time basis. So they would, in principle, not have any other activities outside of their judicial activities. One would imagine that they could still teach, but they should not have anything that's likely to, or could plausibly interfere in their judicial functions. We think it's extremely important to guarantee the independence of adjudicators that would be appointed. And we think the best way to do this, and this comes through bitter experience that we have, in particular in the World Trade Organization, and we would want to have adjudicators appointed for long, non-renewable terms. It's important that they have security in their tenure. In our view, expertise in public international law is what is extremely important, and experience in judicial dispute settlement functions, something which we would think would be advantageous. We would, I think, put less emphasis on expertise in investment law as such. Now, extremely importantly, we would want that adjudicators are appointed not by consensus, but by some form of qualified majority of the contracting parties, after they've been subject to a screening mechanism to check their suitability. There are a number of examples of these types of screening mechanisms. One, I think that is quite well known, is the screening mechanism which is used for the International Criminal Court under the Rome Statute. One of the big criticisms of the existing system is the lack of diversity, both in terms of gender and in terms of regional diversity. And that is something that we think is problematic, and so something that we would want to address, and that we think can only be addressed through a standing court, where those criteria can be set very clearly. I'm speaking too quietly, I'm getting messages from the back. Okay. So something that's extremely important for the European Union, for its member states, is to ensure that we redress the diversity problems which are existing in the current system by building in requirements of gender and regional diversity. And the last element, a substantive element that I wanted to touch on, is on how the system would acquire its coverage. So from our perspective, this has to be done with the consent of the countries that would potentially sign up to the court. I think that's obvious. We would suggest to operate this through an opt-in mechanism. And this would imply that through signing up to the instrument creating the Multilateral Investment Court, or possibly a larger instrument, I think that's one of the issues in UNCITRAL that has to be further worked through. Through signing up to such an instrument, treaty parties would amend the agreements that they may have between themselves. So in other words, when there would be an amendment of a treaty between country A and B, when both country A and B ratify the instrument establishing the Multilateral Investment Court and agree that it should cover that bilateral treaty. And this is not, and so this is a borrowing, this is not a new technique. There is one example of this which UNCITRAL itself has created, which is the Mauritius Convention on Transparency, which works on that basis. And another more and impressively complex version of this technique is the Multilateral Convention to implement tax treaty related measures on base erosion and profit shifting. So this is the so-called BEPS convention, which deals with a very similar problem to the problem that we have in the investment field, which is that there are 3,000 bilateral investment treaties. For taxation, there are around 2,000 double taxation treaties. And this mechanism was used to amend them. Now, as more treaties are covered, then a permanent body would be better able to manage multiple proceedings. As we all know, the current system, it is entirely possible to have disputes about the same issue under different agreements, and if you have different ad hoc tribunals managing that, then that is something which is problematic. And then in the view of the European Union, we would want to have an enforcement mechanism which is essentially self-contained. So in other words, once a decision is made in the Multilateral Investment Court, once, for example, the possibility of appeal is exhausted, then that decision is binding. Now, let me finish with a few brief concluding remarks. So in these comments, I've tried to set out the features which characterize the international investment system. I have suggested that these features are such that the existing system of dispute settlement is not, in fact, well suited for handling the demands of a system such as the international investment regime, where consistency and predictability are key. I've only briefly touched on the question of legitimacy, but that obviously is an important element in our thinking. And finally, I've tried to set out in very broad brush strokes the ideas that the European Union and its member states would put forward as to how a multilateral court should be structured and how it can be established. Something which is, I think, particularly important for me to emphasize and to close with is, and it's important for me to emphasize this today in Johannesburg, is that this is not an imposition of the European Union. It goes without saying, it's the European Union that has put the idea on the table over the last few years, and the European Union is pushing for that as an outcome as part of the UNCITRAL process. But to state the obvious, the European Union cannot make a multilateral court by itself. We have made efforts to ensure that the process is truly multilateral. The European Union and some of its member states donate to an UNCITRAL travel fund that permits the attendance of officials from developing countries to the UNCITRAL meetings. And we've seen the fruits of that, because UNCITRAL Working Group 3, I guess both to Anna's joy, but also sometimes distress, is the largest working group by far in terms of numbers of individuals that take part, in terms of the numbers of delegations that are present. And I think that's attests to the importance that is given to its work, but also to the importance that it be truly multilateral. It goes without saying, and I've said this also, that any court that will come out of this process will operate on the basis of consent. Countries will have to make a sovereign choice whether to sign up for the court. And at least in our vision of it, we need to decide to which agreements such a court would apply. So it is extremely important to engage in this discussion as we're doing today and will continue tomorrow. And I'm truly grateful to Martin, Emmanuel, and Jonathan for having set up this project. And I look forward to the rich exchanges that I'm sure that we will have both today and tomorrow. Thank you very much.
At this point, shall we put the next? So maybe just 10 minutes of questions. Would that be okay? I mean, okay, it's a tight schedule today, but it's so difficult to when you're listening. Jonathan, do you want to moderate this? Sure.
I thought I see it. Yeah, it's your call in terms of organization. I'm happy.
Okay. And Patrick will be helping us with a mic, which we'd like to do for the purposes of recording and so on. Let's start here in the front row.
Hi, I'm Anne van Aken, University of Hamburg. Thanks so much. Colin, I have two quick questions. One is execution, what's envisaged? And then the second issue, the consistency problem. How do you deal with the different underlying treaties?
Do you want to gather some together? Sounds like I remember.
Yeah, let's gather a little bit around.
My question is more, it's more a comment. I would think that perhaps it's just as much as it is important to have regional diversity. Perhaps the different diversity of concept of how to resolve disputes would be quite as important than just because.
Three on the table.
Just building on that, you indicated earlier that your focus is on expertise in public international law, not necessarily investment law. And I'm just thinking about what are your thoughts around the composition of the adjudicators for specific disputes in terms of diversity in the adjudicators for specific disputes?
Let's pause there.
Okay, thank you. I'll since we have 10 minutes, I'll be quick, because some of those questions we could talk about for a very long time. On the question of execution, this is not as such something that we have got into a huge amount of detail. Our thinking is essentially to try to draw as much as we can from the processes of the existing regimes on this. Yeah, so to use or to integrate the ICSID rules on enforcement and to incorporate as necessary rules on execution, so that we essentially can create something very similar to the existing system. There is and I think that is something that is relatively easy to manage and structure for the parties within the parties to the court. What gets more complicated, of course, is where you might be seeking enforcement and execution in countries that are not party to a court. And there we have had debates. I didn't touch on this. But debates about the extent to which it may be continually possible to rely, and this is a fairly complicated drafting technical exercise, to continue to rely on the ICSID Convention or the New York Convention for enforcement, depending, we think, on how these things would be structured in the instrument establishing court. The EU's bilateral practice is precisely to do that. And we have the investment court system adjudicators ruling on the basis either of the UNCITRAL rules or the ICSID rules. And we regard the outcome as still being enforceable in third countries, even if they're not party to the bilateral treaty of the European Union. We could spend much more time on that one, but I'll limit myself to that. On the question of consistency, the consistency evidently cannot override, and the Union has always been clear on this, cannot override the substantive decisions that have been made as to what a particular treaty should look like. That would be an impermissible interpretation. So what we're looking at is consistency where consistency is possible. Our view on this is always that in this large number of treaties, there's a very high degree of homogeneity. They're not identical, but there's a very high degree of similarity. And in interpretations in one treaty will always be relevant and will help an adjudicator address an interpretation under another treaty, even if the wording is not necessarily identical. So it should not be that if we have, let's say, an interpretation of national treatment in one treaty, and a question of national treatment comes up in another treaty, that is automatically applied. But it will nevertheless, we presume, inform an adjudicator in their approach to interpretation in the second treaty. And we also believe, I didn't touch on this for time purposes, but we also consider that it's important also to have mechanisms built into the structure of multilateral investment court or related to multilateral investment court that permit the parties to adopt interpretations to guide the adjudicators when necessary. And that's an issue I'm happy to talk much more about separately. On, maybe just pick up then the last question, just in the interest of time. So our view of specialization is that these are bilateral treaties between two states. What is important is how to interpret those treaties. And the skills and knowledge, the expertise that persons would have in public international law are actually more important in terms of interpretation than those of persons who have more expertise on investment, but maybe insufficient in public international law. The way we have thought about structuring the court would be to have potentially, say, chambers managed by the president of the court that would allocate persons to the individual chambers, not necessarily as a function of their expertise, because their expertise would be screened, if you want, as they're appointed, but more to ensure, I guess, the quality of the outcomes in a particular chamber. We have been toying with the idea, and I think this is in one or two of the presentations that are to come, been toying with the idea of, well, do you start to create specialized chambers? Might it make sense to have chambers that focus on either particular issues or disputes from particular regions? And that's certainly something that we think may make sense. I think the other thing I would say about this is there's a decision to be made in the UNCITRAL working group for the treaty drafters about how much do you lock all of this down in a statute that is then very difficult to change, or how much do you trust both the adjudicators that would be appointed and then the state parties as they manage the instrument over time to make these adjustments and to fine-tune the approach on these particular types of issues. Thank you. Anything else?
Okay.
I see Emmanuel.
I see one hand up, and it's from one of my co-organizers, so I think we're going to take that.
No.
Okay.
My name is Emmanuel from Monash University. So my first question is, do you envisage the MIC to adjudicate on only treaty investment disputes, or could it look at contractual disputes as well? And related to that is the point that you made that the parties will be expected, or at least will be encouraged to change or amend their treaties to bring disputes from, let's say, arbitration, ad hoc arbitration to the MIC. Now, again, that comes back to my first question. So there are some countries that have legislation, domestic legislation, investment promotion legislation, which have an open standing arbitration provision. And these are not in treaties, but domestic legislation. So would they be expected to encourage to change those, amend those as well?
Question to finish with, although it will probably provoke more discussion. So that is an issue which is being debated in the working group. The question of what type of disputes should a permanent body be able to hear. So in our view, it is clear that it should cover treaty-based disputes. It's clear that it should cover also state-to-state disputes. As you know, there are a number of countries that, instead of engaging in investor-state dispute, prefer to use state-to-state dispute. And we think it makes sense that that is covered. There are, of course, also investment laws, investment contracts, where permanent court may make sense. And I think our kind of response to that is something that is something that we are open to. I think we would not want to close the door on the possibility that a standing body be used for those types of disputes. The issue becomes a bit more of a practical administrative one rather than a theoretical one, I think, in the sense that the permanent body would run essentially in contributions by contracting parties. What do you do when you have a single contracting party, for example, that would like to use the court and embed it in its investment law? Should that party pay an additional amount to cover potentially more litigation on that specific law? And similar types of issues come up, I think, with investment contracts. How do you handle the practicalities of these issues, I think, is a more complex problem than the actual question of, well, does it make sense to allow them? I think our basic answer to the question is it makes sense to permit it, but we need to work out the practicalities of how to do it. I see Helen. Oh, yeah. I'm in your hands. It's up to you.
My sense is this really is worthwhile, so I think we should continue. So, but I also feel like perhaps maybe this ought to be our last round. None of the yes. So I'm actually going to say I know that the four of you. Colin's mentioned this. There are huge topics here, but I think let's try to put the questions into a brief period. And Colin's doing extremely well. I'll try to get in compact, substantive answers to them. So let's keep going.
Okay, thank you. I'm Maleba Kemfurere from the law school. So mine is quite short. A lot of countries are envisaging and proposing that there should be exhaustion of local remedies before going to MIC. So my question is, what's going to be the relationship between the national courts and the multilateral investment court? Thank you.
Two quick questions. One is on what you call enforcement, but then you spoke about binding character of the decisions. I think that the binding character of the decisions and the enforcement are two different issues. So maybe a quick clarification on that. And the second, regarding your statement that all BITs should have to be modified to refer to the MIC, but you could also conceive that the convention creating the MIC, if any, could incorporate one provision stating that the state parties to the MIC commit to, by this modify all their BITs with other parties to the treaty creating the MIC, to the effect of incorporating the MIC or replacing by the MIC other dispute settlement provision. I think it seems to me more straightforward.
Thanks. I just wanted to follow up on the point that Emmanuel was making regarding the fact that particularly in African countries, there is a practice of having investment arbitration in the domestic laws, in many contracts, state contracts, concession agreements. And the point has been raised a number of times by African delegations. We are including that now in some of the elements that are ready. So how are we going to make sure that what we do in a code of conduct or in an appellate structure or in a other elements of reform that include that cover international investment disputes in a large sense are not barred from the court?
Mark Bungenberg, Saarland University. You mentioned actually the development of the MIC project over the past now 7-8 years. I think most of us have been following the process quite closely. I think the Secretariat at UNCITRAL is doing a great job. But did you ever regret taking the project to UNCITRAL and not going with like-minded countries a way faster path, because you since actually 2016, 2017 have your own vision of the project, and having to deal with many countries on the consensus-based approach, I find quite difficult.
Do I have a joker? Okay, let me try and answer the different questions quickly. So, exhaustion of local remedies. That's not something that the union favors. We have a different policy approach, which we've worked our way through. But we recognize, of course, that other countries have that approach in their treaties. And we expect that there will be cases where we will have disputes which will have exhausted potential local remedies and that will end up before the permanent court. I think we, the European Union, we don't have a big problem with that. We think having a permanent body is actually a better proposition for dealing with those types of situations, because a permanent body over time can build up I don't know, a rapport, an understanding with senior domestic courts. So the senior domestic courts understand what a permanent body would be doing, and you can have some sort of element of exchange. This is something that we see happening quite frequently, in particular in Europe, but we also see this with other international courts where they have these exchanges with other standing bodies. Sorry, can I be precise? Yeah. Will there be like deference to the domestic courts? So for me, that depends on what type of issue you're talking about deference. So if it's a question of, and this is our perspective, yeah, this is something that will be debated. But if it's a question of application of the law that's included in the treaty, we would say no deference on questions of law. If it's a question of fact-finding where the domestic court had arrived at a conclusion balancing facts, that is not something that we would think would be revisited at an international level. That's how we would foresee that. We know that exhaustion of local remedies is an issue which is important and which is likely to come up further in the debate. On Helene's points, yes, I should have distinguished more clearly between binding character and then questions of enforcement. So our logic is the dispute at having gone through the possibility of a first instance and then appeal, that's final. So you cannot relitigate it, and then we would use the enforcement mechanisms. Our notion on this is to essentially copy the existing enforcement mechanisms that you find in ICSID. And our idea, maybe I didn't also express it very clearly on amendment, is I think very close to what you have described. So the way, this is how some of these other instruments work as well. The idea would be that two countries sign up to the court, and our view is it's better to leave flexibility so that they can decide, do they want all of the treaties to be covered, or do they only want to do some? Do they want to kind of see, if you want, how things develop and then decide whether they want to do it for all? So we don't think it should be a binary choice. And we think that way of doing it is also better for purposes of clarity. So if you're an adjudicator, you're going to have a list of all of the treaties which are amended via the mechanism of the permanent structure, and you're going to know that you can comfortably apply and sit it. You have jurisdiction over a particular case, rather than if a country says all treaties, doesn't list them, dispute comes up, is it clear? So we prefer kind of explicit approach, but the mechanism is the single one through the single instrument. And then on Anna's question, I think you might have noticed the union in the working group acting in this way. So our view is how do we ensure that we have the flexibility? Our view is by ensuring that jurisdiction of a permanent body and the scope of the instruments that we're working on is left always sufficiently open that we can capture investment laws, or we can capture concessions. And so we're not keen on, if you want, modeling or recreating the ICSID type of approach where there's a definition of investment. You have the question what falls under investment, and then you have to look at the underlying treaty. Our kind of conceptual approach to this is you look at the underlying instrument. If the underlying instrument provides a basis, then that's it. There's no additional test. So if we have a mechanism by which, let's say, a state can decide that the permanent body would be the adjudicatory body for disputes under its investment law, we would need a mechanism whereby that is made clear, is made explicit, but we would not want something jurisdictionally that interferes in that function. And I think I'm not sure we've been as explicit as I've just been in the room in UNCITRAL Working Group 3, but that's very much the way that we argue these points in Working Group 3. And then Mark, on regrets. No, look, I mean, so some of you have seen, for example, the problems that the European Union's member states are currently having with the Energy Charter Treaty. Part of the reason for that is because some parliamentarians say, well, it still has the old form of investor-state dispute settlement. It doesn't have this modernized form. And we'd started that work on the reform of the Energy Charter Treaty by saying, we're not going to modernize, or we're going to only make limited modernizations around dispute settlement because we want to achieve that through the Multilateral Investment Court. Why would we multiply and multiply and multiply the instances? So I think to say that we can have no regrets about the speed, no, we would have been very happy had it gone more quickly. We still wanted to go quickly. We're still the ones in the room that are getting angry when the discussions on double hatting, for example, take too long. But on the other hand, I think if we are genuine in talking about creating something which is multilateral and something which is going to hopefully last and be effective, then I think a UN-based process or a multilateral-based process is something that is unavoidable. And so, yes, there will be times when I will be frustrated, and I have been frustrated, and I'm sure that it will happen again in the future. But I think it's the path which makes sense, and we just need to work towards getting to a result in a decent period of time. Okay, thank you very much.
That deserves 2 rounds of applause. So I did notice that most of those questions probably came from the senior scholars who use that distinction. Anyway, I just wanted to point that out as because we're making, to some extent, a pivot, because a big part of this event and the reason why many of the senior scholars have traveled the distance they have is really to get focused on junior scholars and works, papers, commenting and discussion. So more discussion. I think that is our next item. So there's the first panel, which is what we call 4 presenters together with a moderator and 2 commentators. So Emmanuel, I think you're our moderator. I'm one of our commentators. I'm not sure if you think you will, but let's go up. If you need to move around during the 2 hours, you might do so, but otherwise, let's go up. Only 6 chairs. I'll bring a setup just for you or me. I think 6 is enough. I think isn't it 4? No, she's right. Oh, no, 7. No. I can stick.
Physical? No. I know.
Just Multilateral. Here we go.
Okay.
Yeah. No, I'm gonna move around.
Okay. Good afternoon. We will be starting our first set of presentations. Starting the first set of presentations.
Okay. Patrick, could you get the floating mic, please? Okay. Get the floating mic.
I'm very loud.
No, but Emmanuel.
We're trying
Rafia,
to save time. Yeah, so that we don't move. And probably we can.
Doesn't work. The mic.
No, you press. I press one. Okay. I'll be quick, brief, because I think we have kind of eating into the time a little bit. So as the moderator, I'll just start with introducing each speaker. I think the model we'll use is that we will have the first 2 presentations, and then the commentators, the commentator for those 2 will commentate. Then we'll have the next 2, and then we'll get another round of commentary. Then we'll open the floor up for questions. So we will start with Rafia. Rafia the Gama, and to just briefly introduce her. She's a lecturer at the University of South Africa. She's also a consultant in international trade law with an African focus. So she's, it will be wonderful to hear from her. So I'll leave the floor to you straight away.
Thank you. Yeah, as I said, quite loud, so I should be fine. It is, I know I have a presentation, but I'll not be following it completely. From Colin, give me an idea what to focus on a little bit. Firstly, of course, thank you for letting me come there and speak. For the emerging scholar, and I appreciate it. Thank you. I will very briefly touch on a little bit of history, something on the courts in Africa, a lot more on the side of the tribunal, and then I will look at mediation specifically, and I'll put up ADR, alternative dispute resolution, but focusing far more on mediation. And then on the last one, which is really the balancing of fears and comfort levels. It is one of those things I think we are in South Africa, one of almost the first countries who sort of had rushed after 94 to sign a whole lot of PRTs, or before 94, in fact, just before and after, had been brought before arbitration twice, changed their minds, and did not cancel anything yet, which I think is the appropriate thing, because in many cases, sunset clause. Went down the route of coming up with the national legislation, with sort of setting up the system there and moving away from the actions. And that really is, if one looks at UNCTAD's stats, for example, you see the rush of VIT signings. Suddenly you have arbitrations, a bit of a fall off, suddenly people are wanting to change things. The FCTA for investment also shows that there is almost a pivot towards trying to balance things. And that is really what I'm trying to focus on. Is multilateral investment courts is an excellent idea, especially to get away from things like double hatting, the issues around a small group of, dare I say, mixed-room white men.
You dare
mostly
say.
White men who are arbitrators. So it's about that lack of diversity, really. So it's how do we bring in diversity, not just with people, but concepts. And on a continent like Africa, where we do have a history of trying to get to compromise situations where everybody's a little bit happy. So just in terms of the politics and law, this, in the African continent, there'll always be an interplay of politics within any legal system. We've always had that. We of course have, the historical linkages to the different legal systems. We've got the French legal system that still applies in parts, the English one, South Africa being the best of the both worlds, having Roman, Dutch, and the English system. But of course, prior to that, we've always had our own ways of resolving matters. When I say our, of course, I mean the indigenous legal systems, the concept of Ubuntu that sort of underlies most things. And that is something that I don't talk about a lot in the paper, but it sort of colors everything I see. And these linkages, of course, play out economically as well. A lot of when we talk about investors, we are talking about foreign investors coming from particular places in Africa. What we should be thinking about is African investors from Africa to Africa. And I think we don't necessarily always think of those things. How are we going to try and resolve disputes really amongst neighbors, among friends? Okay. So past practices, we've had courts, the AU court, we've got amazing, the African Court of Human Rights, the African Court as well, coming up with really amazing decisions. No bites. And we therefore have a judicial system, even in regionally, was amazing decision. And they're not reflected really in the body of public international law as much as they should. The concepts that are discussed there, the values that are placed in, should be actually a major part of public international law. So of course, the question then for African scholars and African judges, arbitrators, whoever, arises that would we have our concepts being reflected there? When up to now, if you pick up a book, textbook, that's on public international law, how many African cases are there? So that is the kind of thing that we should be questioning, and we should be bringing in to working group 3 and saying, are you reflecting these principles? How are these principles going to be reflected? So those, oh, and I see a typo, of course. So the political bodies, and this is, I've not put much there. SADC Tribunal is just that. It started off, remember, SADC started off as a political body, then became implementable other things, and it still operates like a political body. The tribunal was an amazing idea, perhaps put in place almost like a foreign plant into the in Southern African soil, because it wasn't created for the political situation that we had at hand. It required a unanimous decision, therefore Zimbabwe was able to really stop anything from happening. It was perhaps focused too much on a system similar to what was happening elsewhere. Sorry, did I send you guys the wrong thing now? It's just disappeared. Or is it? Oh. Okay, I'm just gonna go back to this slide. See here. Okay, no. I must have sent you the wrong slides. I do have the right ones in my bag. So the idea that I put forward is firstly that we need to focus on how we try and resolve things on this continent, and not how we should do it. We should all see what's happening and see how we do it already. And in some instances it works and sometimes not. But mediation, where you have this compromise win-win kind of situation, should be not the only step, but the first step at the very least. Yes. The reasoning behind it is that even though there is investment from Africa, it is majorly from South Africa, from Nigeria, from Kenya, there's a handful of countries going into our countries. Yes, those host countries would like that investment to stay, to grow, to thrive. And to do that, you have to create a relationship. And for that reason, mediation works really well. It is also based in the compromised way that we tend to diplomatically sometimes resolve disputes on this continent. And therefore, it is something that we are comfortable with. That's where the comfort level comes in. So that is the one thing that I'm going forward. The second is that we have to quell the fears of the investor, because we do not want foreign investors or internal African investors to uproot and move away. There's always a better market. Not always. Certain kinds of investments are physical and monetary wise very intensive. So one has to keep that in mind. But for those, especially those investments that are easy to move away, it is very important to make sure that mediation, though it is something that I think would be utilized far more here than elsewhere, you have everything else in place. So we do need arbitration. We do need a court system, but we need to make sure that our words and what we like is reflected. The other thing, the final thing that I think is incredibly important to quell the fears of governments is to have that exhaustion of local remedies, because of course they feel very strongly about that. So you need to have some way that this court is almost an appellate version of what is happening. And there is an understanding, and again, this is not just to quell their fears, but also to give the, a certain level of appreciation, of knowledge of the fact that courts in Africa actually work. Because it's very, very patronizing to be told, well, we just go straight there because we don't really trust you, because that is how it is perceived, even though it is not in fact that way. But the perception is there that we go to arbitration immediately, international arbitration, or we go to the multilateral investment court. So exhaustion of local remedies is quite important. Of course, public international law, we know that if there is no real local remedies, that is a reason to get to other forums. So it's not as if that it stops you from going to the multilateral investment court or SDS. And one very last point, because I do see this 3 minutes left, is that we do need to make sure, and this is something keeping in mind, that we do have situations where you will have communities being impacted quite severely by investments, governments being disinterested. Though it is a unidirectional system, we should allow some form of standing for those impacted. And I think there it is essential to take into account exactly that you could have a situation where communities, either they themselves, whether they've been moved, the environment has been impacted, the health is being impacted on very specific grounds. Of course, one can always put in those criteria, but there has to be some form of standing for those communities. So those are the three sort of main thrust of what I'm talking about. Firstly, that commercial mediation should be a big part, that you should have exhaustion of local remedies to actually give the respect to governments as they are. And finally, that you should have standing for local communities. Thank you.
Thank you very much, Rafia. I'm sure there will be a lot of discussion there to follow, but I think we'll go. So I'll go to our next speaker, who is Afolabi. And Afolabi is a PhD student at the University of Faisal, and then he's also a research associate at the Chair of Public International Law under Professor Mark Bundenberg. He's written in this area. He has a number of publications in this area, so we look forward to hearing what he has to tell us this afternoon.
Thank you very much for that kind introduction. It is with a great sense of honor and privilege that I stand before you to present my thoughts to you on the viability of a multilateral investment court as the future of ISDS in Africa. But before I go into my presentation, first I would like to say a special thank you to the organizers for giving me this platform to share my ideas and thoughts on the topic, and also to this amazing institution, to the host for welcoming us into their home. And without any further ado, I would go into the order of my presentation in the next 10 to 11 minutes. Firstly, I will start with a very brief background that will be very short, which would lead me into the heart of my paper on the viability of an MIC for ISDS in Africa, essentially focusing on two critical features. And this will be followed by the practicality of implementing these critical features in the founding statute of an MIC and a conclusion. And basically that's all I have for you. So starting with a brief introduction, the whole idea about the creation of a multilateral investment court revolves around the ongoing discussion on the reform of investor-state dispute settlement system, in particular investment arbitration, as we have heard earlier with the first presentation today. I will not bother you about the reason why we are having this reform discussion today, but I'm more than happy to welcome questions on this at the end of my presentation. But the most important point to point out here now is that we are discussing the future of ISDS. And one reform option that is on the table, which has been championed by the European Union, is the idea of a multilateral investment court with permanent judges as the future of investor-state dispute settlement. I should note, however, that one major issue that has been in the open and been discussed with respect to the MIC as an option is whether or not it is going to address other important issues which is currently bedeviling the current system, in particular with respect to the substantive law considerations that is currently being given no attention in the ongoing UNCITRAL Working Group 3 discussion. And then the question is whether the introduction of an MIC will address the big elephant in the room itself, in the sense of those substantive laws that are in their broadly worded form and in their outdated form that has more or less formed a major catalyst for the criticism against traditional ISDS, in the sense of they allow the expansive interpretation of treaty standards. They allow room for inconsistency in decisions and other vices that I would not like to go into. But then will an MIC, irrespective of the fact that we are not discussing this procedural, this substantive law concerns, will an MIC still be able to address this issue? And I'm of the opinion that yes, there's still room for that in the ongoing negotiation with respect to the establishment of a multilateral investment court. And I have two suggestions that should be implemented in order to have the MIC attractive for investor-state dispute settlement in Africa. This is not to say that these are the only two that is necessary, but they are essentially two steps in the right direction. There are so many other ideas that are worth taking note of, but because of the limited time that I also have, I will just be shedding light on this too. First is incorporating in the MIC statute a guiding note on treaty interpretation. And secondly, an MIC that guarantees investors accountability. On the first option, incorporating in the MIC statute a guiding note on treaty interpretation, what does this help us achieve? Essentially, what it does is to help clarify the meaning of vague substantive standards that we have in the old generation BITs currently in force in their multiples, in their thousands today. And given a study, a comparative study of the CETA on one hand, and then the AFCFTA draft zero investment protocol on the other hand, which as a footnote, I should point out that the draft investment protocol is still under consideration. It's not yet in force, but at least the provisions therein, which we also have in public today, gives us an indication as to the direction in which contracting state parties in the African continent are going towards. And I would, as just an example, point out the fair and equitable treatment standard, including the FPS standard, to show the fact that we don't even disagree as to the understanding that we have on what should be fair and equitable treatment or what should be full protection and security. And if we don't have this disagreement, why not come up with a guiding note on treaty interpretation provided to these tribunals or to the MIC courts that they would use when deliberating on these old BITs that are in their vague form, which has contributed to the criticism against the current system as it is. And as an example, I just captured here, on one hand, the fair and equitable treatment provision in the CETA, Article 810, and on the other hand, the administrative and judicial treatment provision in the draft protocol, which though they did not use the word fair and equitable treatment, it essentially says the same thing to a large extent. And if you just look at the first provision, what does fair and equitable treatment mean as far as the CETA perspective is concerned? You should not carry out the measure that would constitute a denial of justice in criminal, civil, or administrative proceedings. And as highlighted in green, you can see an overlapping understanding under the AFCFTA as well. Similarly, fundamental breach of due process in judicial and administrative proceedings. Also, an highlight in blue, a similar overlapping provision in the African perspective. Manifest arbitrariness, similar perspective as well. So if we do agree in this regard, why not come up with this interpretation notes, which would help tribunals when adjudicating even over these old BITs we currently have in force. And this also solves the problem that we currently have in the sense that the UNCITRAL Working Group 3 is not discussing issues of substantive law concerns. Also, the other example that I am pointing out here is the full protection and security standard provided in Article 10, 810.5 of the CETA. And if you look at Article 16.1 of the AFCFTA investment protocol as well, you see a common understanding that full protection and security should be limited to the physical protection of the investor and its investment. And if that is the common understanding we also have, this helps settle the controversy currently in jurisprudence, whether full protection and security is limited to the physical protection of investors' assets or it extends to legal protection. And this is also another example that shows the fact that we do not disagree as to what does it really mean to have full protection and security provided in this case. On the second recommendation, which I think we could implement, is an MIC that guarantees investors accountability, which could be done either indirectly or directly. With respect to indirect accountability of investors, why not have an MIC that also limits the jurisdiction, its jurisdiction to responsible investment? And this is not impossible. As a matter of fact, we can follow the model that we have currently under ICSID, whereby we have this double barrel test approach that you need to have an investment not only under the underlying BIT, but also one under the ICSID convention. But as a departure from what exists under the ICSID convention, the MIC specifically defines what an investment means in the statute. And I've also pointed at an example here, which basically, is a model, is a Salini model, but including a significant contribution to the whole state's sustainable development, a factor that is critical from an African perspective. And for the direct accountability, this we just need to provide in the underlying IIA. If it allows it, why not? Why can't the MIC court adjudicate over such dispute? Saying that I have very limited time left, I will just finally say that these practical options are implementable either through, directly under the founding statute of the MIC, or we can even have it as an annex to the MIC provision. And on that note, I would like to say thank you for listening to me on this point. And welcome your questions whenever it's time for that. Thank you.
Thank you very much, Afolabi, for a very spirited presentation. I think I will quickly hand over to Jonathan, who will comment on the two papers before we take questions.
Okay, great, thank you. Patrick, I think we agreed you'd give me 8 minutes per paper. So maybe 15 total. Yeah, keep me to that. And in fact, hopefully I'll be faster. But thank you very much, Rafia and Afolabi. Very much appreciated, both of those. I think what I'm going to do from this commentator slot is I'm focusing on the paper. So, and we've, for the reasons of trying to maximize the comments on paper, but really participation and feedback to the junior scholars, I think that's appropriate. There are more comments than what I'm giving through here, but I'll be talking with you and sharing these comments as they go. So Rafia, if I can start on yours, I think I've got 4. And the first one is about the extent to which I think the paper and very much your presentation is using really the idea of, because it is reacting to the MIC proposal in a number of ways, it's, in my view, talking about a concept of an African court. And I think that's particularly because we've got people who've come all this way to discuss this idea. I think that's a worthwhile framing in which to place the proposal for the multilateral investment court. Perhaps it partly goes to what Colin was saying about, it just wasn't feasible to move forward with it in an EU sense, needing to be a multilateral thing. So I think it's very interesting that we've got here some African focused scholarship, and there's almost a parallel with, in a way, the discussion of the International Criminal Court, right? Which you can look at very, very much as an international court, but when you start looking more closely into its subject matter, into the consent that gave its authority, you begin to see the real linkages between that court structure and the continent of Africa. So I think that's a part in your paper, Rafia, that comes out that's worth thinking about in terms of some of that literature and some of that I've put here. Second is the idea of the first plank being dispute resolution in national courts. And that's already come up in some of the questions and some of the discussions here. But I think, let's see, I've got the quotation here as you were setting out the essentiality of allowing for the first instance of dispute resolution to be in national courts. And you're arguing for it really as a matter of principle. And I'm also thinking here in the mode of presentation that Colin was doing of defining the system and defining actually what a court is, that seems to me a linkage with the kind of analysis that you're putting forward in your paper. As a matter of principle, certainly the arguments, and I think we're largely not rehearsing the arguments and the problems of legitimacy, et cetera, in the ISDS system, but not only, certainly from the South African point of view, and we're all aware that since 2015, there's a South African statute that effectively rejects the existing system, that two of the policy points were that the South African Constitution, this amazing legal thing, was sufficient, but it was really more than that. It was really that first point, that national sovereignty and that putting these disputes through national courts would build up the judicial character, et cetera. Okay, that's the second comment. Third one is about, and again, I'll quote, I think from Rafia's paper here, it will be proposed that the cultural and economic imperatives at play in Southern Africa be the lens through which any dispute resolution is visualized. So that's bringing up, and I think some of our questions and discussions have already done that, issues of culture and diversity, different terms in different languages. But if the cultural lens is to be brought in, and I think you're doing it, there are some literature resources. I'm thinking particularly of Juan Cadane's work here on the culture of international arbitration. He's looking at the effects of culture on accuracy, efficiency, fairness, and legitimacy of international arbitration. So that's a third element that, and then the fourth one is it's about the embedded history of actually the South African or Southern African court. So you're talking a bit about the SADC tribunal. That's set within the Southern African region. And some of the literature there, working back to, well, it's broadly within the field because it's the Southern African Customs Union, right? This very old 10. That's a good number, Patrick. Keep that number. SACU, right, is this old customs union that's around. And that's all true, but it's so interesting that you're really looking into its institutional history and taking this with some African scholarship. And some of that scholarship shows that, yeah, okay, SACU can be this respected and oldest customs union, but how equally speaks to the characteristic of that institution for baking in inequality in the region, effectively between South Africa and some of the surrounding states. The terminology here is to argue that South Africa's dominance in the region was hardwired into the geopolitical and regional economic landscape there. And that's something that's gone through at least 3 different periods of renegotiation. So looking at the MIC proposal as a period of negotiation around those kinds of institutional architectures, it's going to be really interesting to keep going with that paper and project. And speaking of really interesting paper and projects, we then have Afolabi, and equally, absolutely. So I'm also speaking very much to the paper there in these, and I'll try and make 4 comments or points. And you know, some of that came through in the presentation, but not quite. Well, there's obviously more in the paper. The first one is, and you and I just had a brief conversation beforehand about, you said you had some ideas of how you were maybe going to rejig the paper. So I've got one, because it seemed to me that in a way, as you, and this is a comment that really won't be so apparent without basically reading the paper, but as you develop the argument of the paper, it seems to me that you're playing with, say, 3 main reform possibilities. And one of them is MIC. Another is other possibilities within procedural law reform. And a third is substantive law reform. And I'm going to actually suggest, and I hope to get to talk to you about it, that may be, I mean, it's more what I actually see in your paper as a 3-way way of going forward. And I mean, it may or may not be the way that other people want to think about that, but I'm going to suggest that that's a appropriate way for you to, yeah, to take that forward. That's the first comment. The second comment is, at the moment, what you're doing is having the paper and its argument turn quite a bit on the PAIC, the, gosh, it's the Pan-African Investment Code, which I learned about quite a lot from Fola Adeleke up there and his work. And I guess in a way, Pan-African Investment Code comes off and you present it at points as consensus and the future, etc. But yet upon examination, it doesn't turn into that. It turns into, it seemed to me what was more empirically resonant was the idea of looking at that code as identifying what you called a divergent approach, which meant a cooling off period before you went to arbitration. So, okay, 5 minutes. So that's the second comment. It's really a kind of an empirical point about the Pan-African Investment Code. And it's also partly the way it works in the paper. Okay, should have 2 more comments here. Yeah, third one, really just in my view, a really interesting, lovely, theoretical problematic that you identified, the linkage between increased transparency and increased centralization. So you've got an amazing you got a couple of paragraphs and some great passages there talking about centralization, in other words, centralization of investor-state disputes into an MIC, and then increased transparency, which you're arguing for in the adoption through the founding statute, which of course is what's under discussion, of the UNCITRAL transparency rules. And you're assuming that that would go hand in hand. So that proposal is in many ways exactly what this kind of workshop is aimed to discuss. It did seem to me that it was worth thinking about, almost for you, it was a presumption or an identification of the alignment between centralization and transparency, that those two would necessarily go together. But would they always be aligned? It's not, it may be worth looking into the opposite as well. And would there be a possibility that a more decentralized structure could also go for increased, or maybe even be more likely to go for increased UNCITRAL transparency? So I really like that theoretical identification there. And then in a similar kind of way, this will be the last comment, is about you're identifying very much that idea, the tension inherent to adjudication of, as you put it, consistency trumping the accuracy of decisions. It comes up a couple of times in your discussion. Also talking about the, you're using the phrase jurisprudence constante. That allowed me to give a French flavor, which is about as far as I can go, but anyway. And I think you're also doing some quoting of some of the senior scholars here. And I think I found that just to be a really interesting discussion of going forward. It mirrors a little bit the centralization transparency idea, but the degree to which, this consistency is actually going to, I don't think you're quite going with a cultural element, but is flushing away the accuracy of the decisions. So I hope I'm raising some issues that are worthwhile, and I look forward with both of you to being able to discuss those papers. I'm going to stop there because you'll tell us what we want.
Thank you, Jonathan. All right, so I'm sure there will be a lot of questions from the participants, but I think the model we decided to adopt is to go to the next set of presentations, and then you're happy to take questions now?
Yeah, I think we'll take,
before we go to the next one. Yeah. All right, okay. We will go that mode. So I can see a lot of hands there. So I will go to Maleba King, and then is that what's your name? Takunda. And then we go to, okay, we'll take 4. All right, we'll go to the ladies at the back, and then that's the first round. And then we will maybe have another round.
Okay, thank you. Interesting papers and fascinating commentary from John. So, a lot of times I hear about Africanization, African culture, and so on. And up to this day, I have never found someone who is able to tell me what this Africanization is. Emmanuel, I've seen your paper. And as an analogy that I can also draw from intellectual property for that matter, we have traditional knowledge that we are seeking to protect, and we are failing to do that in an African way. And what we are seeing is the importation of our Western IP norms into traditional, into traditional knowledge. So I'm here to see what Africanization is. That's one. And I think it goes to both of you, because both of you are talking about bringing into African culture in the MIC. The other one, I hear a lot of this issue coming not only from you, because you raised it as well, but also from everyone who criticized the current exit tribunals. So people talk about the inconsistency and incoherence. That is good, to a certain extent. And I think we have to acknowledge that, because law is not static and economic situations are changing. So we cannot expect that the rulings will forever be the same. And again, I want to draw an analogy in South Africa here. You sometimes read through the decisions of the Constitutional Court and you're like, but yesterday you said something different, but the other week you said something different. So we tend to just shred the decisions of the international tribunals, yet you can see that there are clear elements even in the national court. So I think that needs to be acknowledged in both your papers. So I'll stop here for now. Thank you.
Thank you for the very informative presentations. My question goes to Rafia. You mentioned that African courts are more at the will of political actions. And if you look at generally the history of African courts and the enforcements of their decisions, take for example, the SADC Tribunal, what essentially after the Kembo the decision, that's when Zimbabwe and South Africa said, hey, no, this way we've got to stop this. And even the African court, even from the days of the African Commission, they said, look, with some decisions, we're going to act like they don't exist. So it would appear from my point of view that African countries or African governments are really not interested in international adjudication. So would the Multilateral Investment Court in this case be beneficial to Africa in any instance?
Well, thank you, Toko. And I think just riding on this point, my question is directed to Rafia as well. You mentioned of the African court, and I've just been wondering if you have thought of this African court being an alternative, especially when we look at the Ubuntu, which says it colors everything. And we are also seeing that the SADC Tribunal has given us some indications on where we stand as Africans. We don't want to be sent outside our continent to have to put our dirty linen out there. Can we do it within the African court? And perhaps should the African court be an alternative to that? I don't know if you've thought of that. And the second issue, we have the exhaustion of local remedies and the inclusion of mediation. And we want to see the MIC as being as an appellant version of what should be transparent. Have you also taken into account the cost implications of having all these issues as we move from one step to another? Because when you speak of access to justice and the rest, you also need to speak about the cost implications there. And the other question, or perhaps a comment, which is directed to the second speaker. There's the issue about providing a guiding treaty interpretation. And I've just been wondering of what are the prospects of success in this regard? And we're not going through the unsuccessful OECD attempt of having a multilateral investment agreement as well, and we're smuggling it back door. Just let's have interpretation only as a section. Are we going to be really successful in this regard. And you cannot speak of a treaty interpretation not without going into the substance itself as well. So are we not going that route, which might be so difficult for us? And then when we take a look at the comparison between the CETA and the investment protocol, which is the zero draft for the African Continental Free Trade Agreement, I think we also have to contextualize it in the sense that for the CETA, we have gone at a level which is quite developed, and you see that the provisions are so broad. And when you look at the African parts, the provisions are so narrow. We only speak about physical protection, but when you go to the other side, it becomes so broad. So have we really, are we in agreement on these fetch clauses? Are we really in agreement as it relates to our full protection and security? I think we need to get so much into detail so that we can cover everything. Thank you.
Should I let them respond and then you go? And I think Martin also had his hand up, and then Jonathan. So we'll take the next three. Pardon? You also have a question. All right, let's give them the opportunity to comment, to respond to this set of questions first, and then we can.
Okay. So the, Africanization, similar to the idea of decoloniality, is just, it's whatever somebody wants it to mean. At this point, it seems like it's been, it started off as one thing and everybody has their opinion about it. But to me, and this is quite important, I think there are certain concepts that fit very much from concepts that we have on the continent, perhaps not everywhere, but in most instances. And the first is that we hear not just from the parties to the dispute, but also the community in which they are. With respect to other things, I think, again, I know there's a project currently looking at African courts, different decision-making that has happened. And I think University of Pretoria has a book that they publish quite frequently, I think, on a certain every few years, and that those decisions and distilling the concepts that come from that would be very useful. With regards to how we see certain concepts versus what we import into our linguistics when it comes to law, we have to keep in mind that, of course, we don't just trade with each other, we trade with the world. So we have to, if, for example, the example you used was intellectual property, we will have those rights. What I found fascinating of the intellectual property rights protocol, the AFCTA one, that it started off with plant variety rights and the rights of small farmers, then geographical indications, then the more traditional rights, but also then intellectual indigenous knowledge, but also indigenous cultural expressions. So there are things that they are bringing in, but it has to coexist in the systems that are already in place. And so the idea is that we come up with something that moves all of public international law forward, I think. I'm not quite sure I've responded to you adequately, but that is my point at this point. If we can continue the discussion after as well. I know you'll come to that as well. Can I just do the rest of the ones that were directed at me? So of course, the African courts have had that issue with being quite political and the enforcement of them not actually being followed through. That should not mean that we're not interested in multilateral investment court. In fact, all the negotiations that are happening at the FCTA show that we are interested in having bodies that resolve disputes. However, how we get to those bodies and how the hierarchies are set up, that is something that we need to have that agreement on. And from the negotiations, one can see that they are very firm on exhaustion of local remedies, having consultations before you go to sort of more adversarial systems. And I think that sort of forms part of how we are culturally, at least. And I think that sort of brings back to the concept of Ubuntu and not airing your dirty laundry, but also really making sure that we accept the harm that everyone causes to create the situation we are in. So it's not always one person that carries the full burden of what it is that happened. You have to understand there's always that context. And I think those are very important. So to me, that is the reason why we have that sort of system in place. And of course, at the FCTA, they are negotiating a protocol and investment that may or may not include ISDS. It is quite contentious. It is very political, but it might just be that there is one. It might be opt-in, similar to the Multilateral Investment Court being proposed by the EU. So those are all things that are happening. And I do see that we will move forward with some form of allowance, because of course there's an understanding as a continent, we are very rich in a lot of resources. We have a young population. We have to make the most of it, but we can only do it if we have growth happening because of investment. So there is an understanding of the practical, pragmatic approach as well. I mean, to me, there is of course the cost implication, but there's also that balance that you might just resolve the issue earlier without the cost implication later. But I don't have much more to say about that. Thank you. Oh, sorry.
Thank you very much for those questions. And yes, I completely agree that it is quite difficult for us to determine what exactly is an African culture. Even in the respective families where we all grew up, we have siblings where we really differ when it comes to our personalities. So definitely spot on. And this is the reason why, I'm of the view that the current discussion going on, with respect to the AFCFTA investment protocol, and also importantly, the Pan-African Investment Code, which is more or less the model with respect to what is the African understanding on, the protection of foreign investment. These are guidelines that could tell us what exactly are those core values that is important from an African perspective. And we can draw from this in negotiating with our European counterparts or South American or North American counterparts. And from my study, I have just discovered that we don't disagree to a large extent when we really sit down to really look at what are our values. And I am also, I really appreciate an African adage that really speaks to the fact that if you sit down on the table with someone for just 5 minutes, you'll be surprised how much values you share in common. And so even if we disagree from an abstract point of view, we just need to have that sit down and look at those areas where we align and build forward from there. And this is possible given what we are seeing already in public with respect to what is going on the negotiation on the African Investment Protocol. I also absolutely agree that incoherence is not in itself something that it's not an evil. Sometimes it is just necessary that there should be a departure from what this tribunal said, different from what an earlier tribunal reached. Even in our domestic court system, we do have diversions. One way it's even done very well in the common law is by distinguishing between an earlier case from the present one. So these are fundamental factors that are well entrenched in our judicial system already. Where the problem really lies is where a difference is not justified. And this is also what has been recognized in the ongoing discussions in UNCITRAL Working Group 3, that it's not a problem to have incoherent decisions, but when you look at the similarities in the laws, and you see that there are no difference, but when you look at judicial, or tribunal outcomes, you begin to question why exactly has this tribunal decided otherwise, and you see that there is no reasoning, distinguishing that departure in itself, or providing a justified reason for what the departure is all about, then you have a cause to worry. And this is in itself why this discussion about how best can we entrench consistency in ISDS is being had at UNCITRAL Working Group 3. And in my paper, even though I did not touch on this during my presentation, but it was actually rightly mentioned during the comments about the introduction of a jurisprudence concern idea, which I had. This in itself would help bring some kind of harmony with respect to how an MIC tribunal considers prior decisions, but without necessarily having the current system in which there is no obligation on investment tribunals to consider past decisions. Some of them do, some of them they don't. But if we have an MIC that obliges tribunals or the chambers of the courts when adjudicating over a dispute to pay due regard to earlier decisions, this in itself would make sure that even if there is a departure from an existing case law, it will be reasoned out and we can all follow the reasoning of the tribunal as to why this happened. But in the current practice, a tribunal is not even bound to follow an earlier decision. There's no consequences that flows out of that. So yes, I agree that the inconsistency in itself could be a welcome issue, but it is not welcomed when it is not justified. That is really the concern. With respect to the second question that was addressed to me on the prospect of successfully implementing an interpretation guide. Well, I'm of the view that any treaty negotiation, whether under investment or trade, what have you, is really, really difficult. There is always a lot of back and forth in the room. But if the interpretation note or interpretation guide is going to be a plausible way forward, and this is what would enhance the African interest, despite the fact that we do not have the substantive law issues addressed currently in the Working Group 3 discussions, then why not? We should go for it, and we should begin to start having those critical conversations, especially when it is possible, when our interests are aligned. So that is where I think we can really focus our attention on, not on our differences, but where we have this common understanding, it is easier to build from there. So I think it is actually possible. And yes, there is indeed a difference between the CETA and the AFCFTA investment protocol, which I have cited. And my paper does not even take the view that they should be the same. Absolutely not. But when we look at what we have in these provisions, and we see that we share this common interest as to what certain treaty standard, what they mean. Again, I'm of the view that we can actually build on this, and irrespective of the fact that they are different, and we have to really contextualize these treaties and give them their exact meaning. Fundamentally, if we say that the full protection and security standard in itself should be limited to physical protection of an investor's asset and the investor himself or herself, we do know that even if there are differences in the underlying BIT, for instance, under the investment protocol now, we have a relative FPS provision. It doesn't change the fact that fundamentally this relative provision has to do with the physical protection of an investor's assets. Similarly, under the CETA, and vice versa with respect to the fair and equitable treatment standard as well, where we share this common understanding. And just on a final note on this point, recently the European Union and its member states, including Canada, came up with this declaration on what it really, really means. The provision of Article 810 on the CETA, what it really means. And what can be deduced essentially is that there is a high threshold that needs to be crossed for you to find a breach of the fair and equitable treatment standard. And therefore, it's really a narrow room for you to pass through. And this is also the direction in which African states, are really going. We don't want this broad, expansive interpretation that tribunals provides, currently under the vague standards that we have. So I don't see that we fundamentally differ in our interests. And that is the reason behind this recommendation that I put forward. Thank you.
Thank you very much. I'm sure there's still a lot that can be said, but because of time constraint, we've got to move on. So we will come to, and we appreciate if you can mention your name to us. So we'll go to you, and then Anna, I think is back. And Jonathan, did you have your hand up? Yeah, and then Jonathan. So that will be 3. We have a lot. Okay, so we'll take these 3, and then we'll have one last. Oh, okay. We'll take the three, and please, if we can take 4. Okay, so we will. Michael, did you want to ask a question? Okay, we'll take those 4, and please, if you can be very brief, we'll be grateful.
Thank you so much. My name is Kathleen, and my question is directed at Rafia. I just wanted to find out your thoughts on the relationship between mediation and exhaustion of local remedies in the context that they would mostly be proposed as prerequisites to accessing the multilateral investment court.
Thank you very much. I wanted to actually comment on the proposal by Rafia to strengthen recourse to mediation, which is really one of the reform pillars in Working Group 3. And I wondered why she was referring to commercial mediation and not going one step further and saying investor-state mediation. I also wanted to refer to exhaustion of local remedies, which is a buzzword that we are hearing everywhere when you talk about the reform. The important element is to reintroduce the domestic courts. And the question is it exhaustion or is it recourse? So how far and how long do you have to wait for a decision to be made by the domestic courts before you can go to another remedy? And the third question I have is for Afolabi. I'm not very clear, but I didn't have the benefit of reading your paper, so please apologies if I didn't understand it very well. So what you're advocating is that the parties to the Multilateral Investment Court or to the broader reform framework convention have an ability to come up with interpretation of substantive standards? Or is it that you want to have tools for treaty parties or to enhance the tools for treaty parties to interpret? So one is to have a procedural tool that allows treaty parties to intervene, to say, to clarify, to say what they mean under this or that standard. And the other one is that they actually interpret, and this interpretation becomes binding on arbitral or other tribunals. Thank you.
Thank you, and Michael Kanu. So I'm the other UNCITRAL delegate in the room. I firstly want to thank you, Rafia, and then Afolabi for I think your papers and presentations. I wanted to ask a question since related to the issue of one, inclusivity of ideas. So that's you, Rafia, and then on this interpretation guide. And since we were talking about establishing a court, so I was thinking in the instrument establishing the MIC, what do you think of a provision on advisory opinion? We've seen how advisory opinion has shaped international law. ICJ it lost in terms of the Nauru advisory opinion. Just wondering liability. I'm wondering if this is something which can address this gap in substantive rules whilst we're looking at procedural issues, working group 3. Thank you.
Thank you so much. I'm Jonathan from the University of Pretoria. I initially had 2 questions, one for each presenter, but I think I will go with Afolabi and maybe with Rafia, we can have time to talk after. So it's still about this proposal for guiding interpretation. And I was wondering, because this issue is a kind of contentious one between the judiciary, let's say investment tribunals, and states. And if we look at one recent case like Eco-Oro, which is in which a new generation investment agreement with all those clarifications was applied, and in which the 2 states issue a joint interpretive statement, we saw that at the end, the tribunal did not follow the interpretation. So my question is, what if the tribunal does not follow? So just to make it short, but I think we can have time to talk after. Thanks.
I think mine are just short questions. The issue of guiding stroke interpretation notes, as Afolabi suggests, is the way to go when it comes to MIC. Is the issue is that will it limit judges' discretion, therefore affecting the quality of decision made by judges? Does the Vienna Convention on Law of Treaties offer enough guideline already to necessitate then having another guiding notes which shall effectively translate to almost a major part of the convention, which the parties are not already agreeing on setting up the court? So why then do you think they will even agree on the guiding notes? That would be all. Thank you.
You go first. Okay. All right. So on the first question, with respect to the guiding notes, clarifying what I really mean by that. So essentially what I am proposing is to have this guiding note. It could be regarded as a procedural, so the word, the terminology doesn't really matter, but essentially having this in the MIC statute, whether implemented directly as a provision on the statute or even as an annex to the MIC statute, that essentially provides the common understanding of the parties on what these substantive standards, what they mean, where they agree. And this can be done in the annex or directly in the treaty provision itself. So I don't know if that really clarifies the question, but we can elaborate further on it after the conference today. Also, whether or not there should be the decisions of the MIC court should be binding. Did I get that question correctly? Binding on other tribunals? Did I get the question correctly that you... The advisory opinions, yes. Whether they should be binding on the court? No. Okay. So maybe I did not get the question correctly then, because I was trying to note them, but fundamentally, it is not possible to have a binding decision on other tribunals. Each case would be only binding on the parties directly involved in that case. So, but we can discuss further on this later in after the conference. With respect to the question on what if the MIC does not follow the guiding interpretation note, it is my view that well, that would directly impact on the legitimacy of the court itself and the direction in which the court will not want to go in, because this is also part of what has triggered the backlash against the current system in situations whereby tribunals just decide to go against the will of the parties. And I do not think the MIC court will want to repeat such an history, because definitely its existence is conditioned on that in itself. So yes, I would just keep it to that. Thank you.
I'm going to try and answer a couple of the things together, if I may. Because I think there were two issues on how the sort of local exhaustion of local remedies will work in mediation and so forth. The way firstly, just I'm talking about commercial mediation because it is wider than just investment. And I know, of course, this is to do with the Multilateral Investment Court. I do foresee that there will be issues that countries will agree to certain things wider than just investment, but they are interlinked somehow. So I'm thinking of situations that could possibly kind of fall in. So I'm thinking commercial arbitration just to make it a little bit wider, mediation. And the reason I talk about commercial mediation is that I'm not talking about including things in, but I'm excluding family, labor, certain things. So I'm sort of trying to make it very specific. With regard to exhaustion of local remedies and sort of the new trend to have national focal points for investors and things like that, and it provides certain services, is to create systems in place that will force a choice, a fork in the road. You choose mediation, arbitration nationally, and then you can go to the tribunal, or you go to the court system. So those kind of situations, that is something that each country will end up having to set up for themselves to decide where those forks in the road will come in. Of course, even with a national arbitration, you can always appeal or take things on review in local courts. So then it becomes some sort of ladders and, going laterally and then ladders again. And I think that is something that I would love to investigate in the second paper, to see how those systems should happen and whether you allow for multiple bites at the cherry, or do you set up very sort of strict adherence to, you choose this and that's it, that's your choice, you cannot move forward. And I would love to sort of investigate how those systems will work. But I haven't really thought about it for this paper. But I'm glad you brought it up because it is an issue, a very important one. So when I talk about exhaustion of local remedies, I'm talking about recourse, not complete exhaustion, because of course, even the concept as it exists in international law, exhaustion of local remedies does not mean that you have to exhaust every single local remedy. If you can show that using them would actually just is an impediment to receiving a justice, then that also is problematic. So it's in international law, there is a limit to that. When I talk about inclusivity of ideas, it's exactly that. We're trying to and include as many of the different things. Advisory opinions are actually a great way of doing it, and it might be something that should be considered to allow for advisory opinions. Of course, they can be ignored, but they still move forward, the wheels of development of legal concepts. So I really like that idea. That is an excellent way of bringing in concepts. Thank you.
Thank you. I know that there are still some burning questions out there, but I'm so sorry that I have to kind of end the question time at this point in order not to disadvantage the following presenters too much. So we're already kind of eating into their time. So without further ado, I'm going to introduce the next two speakers, and then hopefully we'll get some more questions. And hopefully some of the questions that you have now, you may be able to direct them to the next speakers and have answers, or have the discussions and the debates to follow. Okay, so I'll go very quickly. Our next presenter is Marie-Louise Aren. She is a PhD candidate at the University of Pretoria. Her expertise is in international economic law. She is a principal research fellow, and she's going to talk to us about the applicability, the applicable substantive law of the MIC. So, leave the floor.
Good afternoon, everyone. Can you hear me? I'm wondering if I should use the microphone. Thank you. First of all,
does that microphone not work?
Thank you. Before I commence my presentation, I would like to thank the organizers for giving me the opportunity to present today here. I will try my best to make my presentation within the allotted time. So my topic for presentation is the applicable substantive law of the, so let's say the proposed applicable substantive law of the MIC vis-a-vis African investment interest. So I'm looking at the concerns and the options. So my presentation is structured on using the background, giving a background. I will also look at the MIC and what it proposes. I would look at the African common interests taken from the Pan-African Investment Code. I would also speak on the feasibility of the MIC vis-a-vis African interest, and I would wrap up giving my recommendations. So without saying too much, because most of it has already been said, globally, we know that the investor-state dispute system has been criticized for many years for its institutional and substantive deficiencies. And bringing it back to Africa, Africa has really been at the receiving end of this system, being that it's a developing continent with very limited resources, yet most of its fund goes to settling investment disputes. So as a result of this issue, the MIC has emerged to provide some sort of solution to the investment state arbitration problem. But despite this MIC emerging, the major question is that, is it legally feasible, particularly coming from an African perspective? What are the benefits and what are the costs to Africa? So in answering this question, we must first of all ask ourselves, what are African interests? Like the lady in front of me mentioned, it's difficult to come up with an African position because African countries are different and have different interests. However, there are common interests that are unique to Africa that has been codified in the Pan-African Investment Code, which we can draw and come up with an African position. So first of all, Africa's investment interest is that it wants to draw in investment because through investment, it will be able to get funds to meet its development goals. At the same time, the conditions for these investments coming into Africa is very problematic because the current investment regime is very one-sided. It protects the investor compared to Africa. And if we say an investment agreement is a contract of sorts, the question is, why does it favor one why does it favor one party against the other party? So another interest for Africa is attracting, like I mentioned, responsible and sustainable development investment. Another interest for Africa is protecting its regulatory rights and its natural resources, because most of the investment dispute claims are on Africa's resource or natural resource industry. And Africa also is interested in being having inclusive representation, and its sovereignty also is at stake. So what are some of the substantive provisions that the MIC potentially comes up with? It offers or brings an opportunity for choice and uniformity of laws, permanent interpreters, and independent judges that can provide very clear judgments. It also brings up the issue, it also provides judicial investigation to cases where the courts can go outside of the claimants to investigate the issues that are before it. It provides an opportunity to develop its own procedural rules and brings in potential standards such as transparency and efficiency. So against this backdrop of African interests and and the feasibility of, it's very small, thank you. And the feasibility of the MIC, I'm looking at it from two aspects. First of all, what are the potential benefits for Africa if it decides to join the MIC bandwagon? First of all, it potentially ensures the investment of consistency of investment decisions because of the permanence of adjudicators. It reduces the costs or cost of proceedings because the adjudicators will be paid an annual income compared to arbitrators where they are paid on an ad hoc basis. It potentially removes the vast unpredictability and inconsistency of arbitration awards, and it can possibly lead to the development of an investment procedure jurisprudence that will be useful going forward. However, there are costs associated with this investment court proposal that might just not work in Africa's interest. First of all, the investment court does not address the main issue that Africa has always complained about, the investment regime. It doesn't address the substantive issues. So while the multilateral investment court is a great idea, I see it as putting the horse before the cart. So for the courts to consider African interests, it must first of all deal with, or the investment regime should first of all deal with the substantive issues that are facing Africa, facing investment, which is balancing investment interests. The interest of the state and the interest of the investors, as well as third-party stakeholders, should be considered. Secondly, the multilateral investment court does not really address the threat to African sovereignty, because African countries are very protective about their sovereignty. They are very reluctant to submitting themselves to investment tribunals or any form of international tribunals where they don't really have a say in what goes on, and they are bound by the decisions that these tribunals enforce on them. Thirdly, African investment resolution seems to be focused based on the Pan-African Code, and many decided cases seems to focus more on dispute prevention than dispute resolution. So it's quite similar and quite similar to developing country interests, particularly when we look at countries like Brazil, where they care about dispute resolution, because eventually at the end of the day, when the investor wants to make money and the state wants development. So going through an investment court, will that meet these interests? I don't think so. It will not meet the interest. Also, there's also the issue of appointment of the adjudicators. How would they be appointed? What laws will be used? What criteria will be used? Where would they be picked from? Would there be inclusivity? Would there be more African, or would there be some African adjudicators? And would African laws like the African Continental Free Trade Investment Protocols be used? So these are not very clear from the MIC proposal. So my recommendation is that the MIC it's good in coming up with reforming the investment system, but I'm quite pessimistic about its purpose, because for years, developing countries have been saying the same thing that the MIC is saying, reform the system, but nothing has been done. So why is it that it's now that this reform is taking place? Who is benefiting more from this reform? Does the reform of the MIC address the power asymmetry between developed countries, the EU, America, and Africa? Doesn't seem to address it, in my opinion. Also, Alvarez Zarate maintains that the MIC is being proposed now because the global north tiptoes around issues that are of profound interest to developing countries until those issues begin to affect them concretely. So my recommendation is that there must be a willingness to dialogue and reach a soft consensus on the fundamental contents of in the investment regime, international investment regime, the substantive laws, fair and equitable treatment of investments, stabilization clauses, and all those clauses that ensure that investors are protected. So it's very important to address that first. Then we can talk about the issue of the MIC. And for African countries, my advice or my recommendation is that Africa should contribute, of course, to the to negotiations and to the development of the MIC, but it should be very cautious in signing up to any agreements that would lead bind it going forward. African countries are advised, in conclusion, to fully determine whether the MIC proposal align with their best interest, doing a cost and benefit analysis, and then take it up from there. Thank you.
We'll now move on to Peter. Peter Moruti. Peter teaches at the University of Nairobi. He's also a partner of a law firm, MPL Advocates LLP. He's an advocate of the High Court of Kenya, holds LLB and LLM in the field of international economic law. Peter, the floor is yours.
Maybe I use the microphone, but maybe I hope I'll be audible. So I hope you can hear me. First, I'm grateful to be here. For the organizers, we are really grateful as young scholars to have this opportunity. However, I hope to keep it short and sweet. I don't have the slides. Reason being, I also want to donate some time back to all of us to ask some questions. So mine will be very straightforward. I'll use maybe just 4 minutes. My idea, which I came with here, is how then do we uphold state sovereignty when constituting this court we are calling MIC? That was all the issues I was grappling with. So my phantom idea was this always known principle of concept of consent, meaning at the inception of this court, all the parties who are going to be members of it should have consent, and that consent must be so clear that no party feels cheated at any point. Because, as you know, the applicability and enforcement and recognitions of whether awards or decisions is based on whether a party thinks this was a fair process and a process it is submitted to willingly. Noting in mind, the most important parties in this process are states. So what do states claim? At the very onset, states always claim we are sovereign, so you cannot sue me. So then the only way they are allowed to be sued if they have consented to it. In fact, if I sit down with that, I will have done justice to my paper. But I'll make 4 or 5 comments, then I'll leave you with some questions. The comments are as follows. 1, at what point do we have this consent? Maybe this consent should look at issues of, even if a state has consented to the convention itself, it doesn't mean it has consented to all disputes. We should have in that convention even classification of that a state can choose these specific investments is what we want to submit to court. Because with that, it means even if a state might not agree with the concept of MIC, the state itself can say these specific disputes can go to MIC. So with that in mind, in the reservation clauses, the Kenya as a country, for example, or South Africa, will then assent to the convention because it's clear in mind that these are the disputes it wants to resolve. The other issue is, which has been touched on by my colleagues here, is the unequal bargaining power when it comes to the concept of consent. Let's take this practically a bit. I think we need to have an example for this one. Take in mind, Coca-Cola want to invest in Kenya and says we want to build a very big industrial company, but the only requirement is that in that BIT, you must have the forum for dispute resolution to be MIC. Now, first, the GDP for Coca-Cola is more than Kenya. 2, this Coca-Cola is telling Kenya, if you refuse, there is Uganda. And in fact, the land of Mandela is waiting for us. So this consent, Kenya might enter into that BIT, but in real sense, it has not consented to going to MIC. So eventually, when a dispute occurs and Kenya is referred or dragged kicking and screaming to MIC, it will be saying, why are you taking us there? Consequent of that, the court will enter a judgment in default. Then we start going against Kenya. Now the bad wagon starts. Kenya, you cannot fly to South Africa. If you go there, the airplane will be landed and you'll be taken. That has happened to Tanzania, just to be aware here. So to deal with that, maybe I'll go the way I think the first presenter was recommending, something called, but I will name it differently. It's called multi-tiered dispute resolution clauses. This means at the very onset, Kenya is given an option of having a negotiation before you take me to MIC. It might not be the silver bullet to address unequal bargaining power, but at the very least, I've given you an idea to think along. So Kenya, you'll be saying, before you take me to MIC, consensually or not, let me first try and negotiate with you and see if there is a way out. Maybe in that negotiation, you get an answer. So in short, as I conclude, my paper proposes the following, that this concept should be so clear and should have in various, if you read my papers, I've given various examples of consents. For example, you don't want Johannesburg going to the court of IMC without the South Africa as a state consenting to that. So you don't want a state in South Africa or a region in South Africa having the jurisdiction to go to MIC until the South Africa as a country has done that. You also want to have reservations against certain consents. Kenya can say issues of human rights where, for example, there's an issue on environment and that investment is going to touch on environment, let it not go to MIC. Let's say deal it through mediation or any other thing. So essentially I propose that when I state that the need to approach state sovereignty through the concept of consent is that the only way we can uphold co-sovereignty of states in establishment of this court is incorporating very clear consensual clauses in the treaty itself. That's all. Thank you.
Thank you.
Thank you very much. So first of all, I would like to thank the organizers for having invited me to contribute to this, this event and this very rich discussion.
And second, I would like to congratulate the two people for the papers I will comment on. Thank you very much. It was somehow a challenging reading because I hear very strong ideas here. And of course, coming from Europe, I don't hear such strong statements about African interest, even if I'm very sensitive to TWAIL approach, to international law, to the global discussion around decolonization. But nevertheless, I mean, the strength of these statements is very interesting to me. So like Jonathan, I'm going to comment mostly on the papers. And I have to say that in both your case, your oral presentation was quite different from the paper, especially the second one, I have to say. And so you're probably aware of that. So I will adjust my comments. I would have tons of comments. I've made pages of notes. I've commented in the papers as well. So maybe what I can do is send them afterwards and just concentrate on the bulk of my comments. My first comment for Marie-Louise is, so you focus on the applicable substantive law. So your focus is on substantive law, and this is an idea we have seen with many speakers. And yet you comment on a project, the MIC, which is mostly a procedural project. And everyone is aware that all the reforms which are ongoing are focusing in principle on procedural issues, but that the elephant in the room is indeed substantive law. And the problem is, how do you approach this issue of substantive law through speaking about a procedural reform? And in fact, in your paper, you mix both. And it's not always easy to distinguish. And maybe what was, maybe you have this well-known diagnosis that international investment law mostly developed in the wake of decolonization, end of the 1950s and so on. And this indeed tended to crystallize some interest related to decolonization and especially inequalities. Of this we are fully aware. And the arbitration which came with this international investment law was mostly set up to remedy what was considered as flawed national judiciaries. And the understanding of the need of this international level was related to this flawed national level. And this explains why we do not have exhaustion of local remedies so far. So, and the second, I would say there is a second dimension, which is how arbitration, investment arbitration, which has mostly developed in the 1990s, which is more than 20 years after it started to be set up. So you have a temporal sequence, which should be taken into account, in my view. And the second issue is to which extent this development of arbitration has increased the flows of international investment law. And my perception is that maybe distinguishing these two times in the sequence could be useful, because in my view, the Multilateral Investment Court aims first at remedying the flows of the second time of the sequence, in the sense that with the hope that it will facilitate remedying to the flows of the first sequence, the first time of the sequence, if you understand what I mean. Not that the idea is not to remedy to inequalities, but the idea is that by remedying from inside to the flows of the procedures will help remedying to the flows of the substance. In a context where, for people working on reform, it's hardly conceivable to tackle globally the issue of inequalities of substance with 3,000 BITs and the impossibility to have a net which is narrow enough to catch all in it. So this is one approach. And another approach, of course, could be to say, okay, it's the system, like is said by Sonaraja and Koskiniemi, let's put the system down because this system cannot be remedied. So you have two possible approach. And I would say the approach of the MIC, in my view, is a kind of incremental approach, which take the reverse sequence of the development of international investment law. So, but the issue is the MIC as such is not intended to deal with substantive law, neither the reform which is discussed in UNCITRAL Working Group 3. So the problem of reproaching constantly the flows of substantive law in a context where it is not discussed creates a discrepancy in the reasoning. So I think it would be good to distinguish more between both and to see this in, I would say, in a temporal perspective. Now, regarding the more specific, what you call African aspect, because I'm also very happy about this discussion and the question which was raised to understand what you call Africanization. And at the same time, I have to say that I see what is Europeanization, even if I could see the diversity of European countries. So the problem is, how do you overcome your diversity? Not suppressing it, but trying to build common interests. And it's not easy because Africa is a huge continent with a lot of diversity and more than 50 countries. But I understand that if you come back to exhaustion of local remedies, you will, I think it's less than that because I was given 10 minutes and you give me 10 again and I've already been speaking, but I'm ready to take this if the chair allows me. No. So, no, I will try not to abuse, but I know it's easy to lose track of time when one speaks. So regarding this African interest, I have mostly noticed two aspects that you have both tackled somehow. One is exhaustion of local remedies. And what I find interesting in this is that on the one hand, it presupposes to, as you stated, to reinstate trust in the national judiciaries and conceive the MIC only as a complementary system, a bit like, even if my comparison will be shocking, the International Criminal Court. I mean, priority goes to national judiciaries, and only if they fail, it should go to the international level. The downside of this is when you have the feeling that too many national judiciaries are failing, and it is widely exposed. And so this is the problem is to self-trust the national judiciaries to go in direction of that, in my view. So I think it's the other side of the coin when you promote exhaustion of local remedies. It's not only to revindicate sovereignty or dignity. It's also to take into account that this belief in the national judiciary should be able to hold in the face of international litigation. This is what I mean, and it has to be thought through this lens as well. And I do not presuppose anything by saying that just that the two sides of the coin have to be looked at. And the other thing I've heard, of course, are very much procedural issues relating to the MIC. So regarding the composition, it has already been discussed. It will be discussed a lot again. I will not comment on that. We will revert to that. But I would like to say a word on comment, to say a few words on Peter's paper. This sensitivity to consent seems to me very important indeed, and the issue is to underline that this sensitivity to consent comes from the impression of always being the loser in any international bargain. At the same time, formally speaking, African states have the same consent than any other states. So the problem is, how do you craft procedure to give the impression that this consent will have to be respected? And my feeling when I read your paper is that at the end of the day, it was about choosing how the treaty on the MIC would approach this. Is it that by becoming party to this treaty, you accept the jurisdiction of the MIC as a kind of compulsory jurisdiction? Or do you craft your consent that you can become party to the treaty creating the MIC, but then you will have a system of optional declaration like exists for the International Court of Justice, Article 36 of its statute, where each country will say for which BIT and maybe for which type of disputes the jurisdiction of the MIC is accepted. This is what we discussed briefly a bit earlier with Colin. And so either you go for that or something which is not fully clear in your paper, whether, because at some point one could have the impression that you were pleading for the fact that the state should have to give the consent ad hoc for each case. And there, if you go for an ad hoc acceptance, I'm not sure I see the point of creating the whole system, because it means that states can just drop out every time they find it convenient. So you revert back to the good old system. So I think it would be useful to clarify and then to focus of this. Do you add to the fact of becoming party to the treaty a system of opt-in declaration or opt-out declaration? You have several systems which are conceivable and which would be worth to study more in depth to precisely valorize your idea around consent, because this issue of reservation has been very much discussed regarding the optional declaration at the ICJ, and so a comparison could help you a lot. And it leads me to my last remark, if the chair allows me, which is that in your paper, at least, it was less obvious in the presentation, but in your paper, you speak also like if states would bring cases to the MIC. And your paper did give the feeling that you speak mostly about interstate cases. And yet the bulk of cases that is expected is investor state. And one big issue now is this asymmetric situation, which makes until now the state being always the respondent. So you have the issue of the state becoming a claimant, but also you have this, when you speak about consent, it's you have this the issue of counterclaims, which was evoked, of course, but you have also the issue of the mixed character of most of the disputes. They are not interstate. So in terms of consent, you have to take this into account, because in fact, the current system is based on the fact that states make an offer to arbitrate, and by bringing a case, the investor accepts this offer. And so you see that the consent is considered as being here. But when you're in this kind of system, being it interstate or investor states, the litigants fight mostly over jurisdiction. And so jurisdiction is very important to discuss when you speak about this issue of consent. I mean, tackling consent leads you to tackle jurisdiction. And all cases at the ICJ, for example, you can see that in case optional declaration are used, then you have a fight over jurisdiction, because states always try to escape the courts. So thank you very much for your attention. I would have dozens of other comments to make, but I will let a chance to the people to ask questions. Thank you very much for your attention.
Thank you very much, Elaine. All right, I think we might have a few minutes for some questions. So I will crave your indulgence to allow me to give the floor first to those who have not gotten the opportunity to ask questions. And then I'm not saying that you shouldn't raise your hand if you've asked a question, but I will give preference to those who couldn't ask their questions first, and then I'll give to those who were able to ask their questions previously. So can I see any hands? I think Anna, I saw your hand. I don't think you've asked any. You didn't ask a question in the first. So yeah, I'll go to you. Mauto, I will come to you. I think you didn't ask your question, and Martin, you didn't ask your question. So I'll go. Yeah, first three.
Thank you. Sorry. Okay, I have two, one for Marie-Louise and one for Peter, and somehow it's a follow-up to what Elaine has said. So and maybe it's even a question for Colin. Is he still here?
No,
just popped out.
Oh, that's bad. If he comes back, maybe, yeah. Yeah, yeah. I think anyway, he hasn't asked any questions. So can I bring this up?
Mauto, yes.
Thank you so much. My name is Mauto Tosa. I would like to draw my question from the comment of Professor Hélène Louise Fabry. I'm wondering isn't it time to include substantive reform in the procedural reform done in the framework of the UNCITRAL Group 3? Because I think it is very important to tackle this point too. If we ignore this aspect, I think it will be difficult to implement procedural reform, as Marie-Louise said. And we are lucky enough to have here the official of the UNCITRAL. Maybe they will tell us something about it. And nowadays, African countries made a very great effort in reform of investment regime. And I will point out the effort of regional economic community like ECOWAS that adopted ECOWAS investment code. In the framework of COMESA, we will revise COMESA investment agreement. The East African community have a text, even if they are not enforced. My question is this: are these legal instruments about investment, are they used in the framework of the UNCITRAL discussion? This is my question. Thank you.
Martin? Yeah.
I'll ask him later. It's provocative anyway. So I like this this point of Elaine of reforming the substantive through the procedural. What it actually boils down to, that what's all important is the people who are adjudicating, and the BITs, even the old ones, could have played out totally differently if the arbitrations would have been different, and without going praeter legem or even contra legem. So the question is, if we exchange the people, and this is what I found so interesting when they said they don't even want people with investment law experience, they want public international lawyers, meaning they're basically shutting out probably 80% of the arbitrators which are now sitting. Yeah. And that is interesting, because that could mean that could be really a total tipping point for the system. And then I wonder if that is true, how much of the, I'm always saying, and probably the paper or the book of Wolfgang Alschner on new treaties, old outcomes. So no matter what you put in the treaties, they will still continue to adjudicate whatever they want to adjudicate. So I would always have said, if you talk, I don't look at the video of the OECD on investment law and climate change, and Philip Sands has a point there where he basically, who was sitting in the Eco-Oro case, he basically said, well, they just never look at the Vienna Convention, and they certainly never look at Article 31(3)(c) of the Vienna Convention. So, either you just put them in what sort of rules they have to follow for interpretation more clearly, but even then, given now the Alschner book, I'm not even sure that is anything to do with. So I think even from the African perspective, it makes sense to reconsider the multilateral court if the multilateral court is a trick to exchange the arbitral community. That's what I wanted to ask Colin, but he's not here, but maybe they have it in mind. The other question is to Peter on consent. And in my other life, I'm doing international law and psychology, from which we know that default rules are so incredibly important. So consent is always opt-in, as we understand it in international law. But of course, consent could also be opt-out. So, you know, and we have the system, if you look at through that lens, treaties are opt-in on the first layer, but then reservations are a sub-opt-out. And you can play with this opt-out, opt-in, opt-out, opt-in. And it's incredibly forceful, the default systems, not only for individuals, where we know this from organ donation, it makes an opt-in gives you 10%, opt-out system gives you 90%. And we have the same thing, the wonderful study of Jean Galbraith, which you might have alluded to, which shows the same thing for consent to jurisdiction for states. Now, that shouldn't be the case if we assume states are rational. They're obviously not. It somehow matters. Default rules really matter. So I would suggest to you to look to the consent issues through that lens. And I'm happy through that lens, through this default law psychological lens, and I'm happy to give you some references later.
Thank you. Martin, and yeah, Martin.
It's still on? Yeah, it is on. My comment slash question goes to Marie-Louise. I suspect, and this is probably for other people who are writing about substantive law, if you walk down the road of saying that there needs to be a further step and there needs to be a reform of substantive law, there are a couple of things that you'll always have to think about. The first one is the history of failures in this area. So I think in the 50s, there was an attempt to create a multilateral treaty on investment protection. It failed, and because of its failure, then they went and made the UNCITRAL treaty because they thought, well, procedure will be a bit easier. There was another attempt in the 90s, I think by the OECD. That one, of course, also fell over. So if you go for a third attempt, I think you would have to address the issue, why do we think it might work now? The other issue I think you might also have to think about is, sorry, it's just jumped from my mind because something else jumped in. There's just on a side point, it does cost so much in resources to get through all of these debates. And you'll have to wonder whether anyone has the appetite to keep going. It was interesting when Mark asked Colin earlier about the processes over the past 7 years, and you notice at the beginning of his answer he couldn't quite get it out. So I suppose it's been exhausting, and I suspect substantive law would also be quite exhausting. But coming to my final point, and I think one of the more important ones, perhaps it's actually a strength of the system to have it so fragmented, because states can set up their own investment treaty programs and say, this is where we operate from. Of course, if you have two states that come together and they have their own models, then yeah, obviously the stronger state might be able to prevail, but you'd hope there's enough common ground there where they can find some compromises. So the fact that we don't have a multilateral treaty, maybe that's ultimately a good thing for states. They have some flexibility about how do we want to, or what standards do we want to be held accountable to? But I really enjoyed your presentation, so thank you.
I think, was it Anna? Yeah, okay. And Jonathan, did you have your hand? Okay, no, Jonathan, okay. Oh, okay, all right. Jonathan, do you have your hand up? Okay, I will give you, okay. I'll give Jonathan, and then, is it Fola, did you have your hand up or your question is answered? You're happy? All right, we'll take this last one, this, and then Malibeke, and then we'll end, we'll wrap up.
Okay, thank you. My question is for Peter. I'm afraid not to have understood your point about negotiation under the multilateral investment court, because negotiation currently exists under international law, and even during the proceedings, party can still negotiate. This is what we saw recently with Shell against Nigeria. So my question is, are you referring to such an obligation, or are you proposing something new? And if that's the case, how can it be different from the obligation we know under international law?
Lucky last.
Thank you. I think to the panel and also to the previous speakers, that they really take into account what Martin has just said about the failures that have happened in this field, because even the papers that I was reading, I don't see that element being addressed. And I think it's very important. We cannot talk about the possibility of doing something that is actually impossible. And, you know, with the OECD, remember, it was just a group of like-minded countries that actually failed. Now think of, you know, the multilateral investment treaty with substantive laws, whether it is something which is possible or not. And again, the other thing that I would like the speakers to take into account is, again, look at the regional courts and even the African court now, and look what they are doing, because again, you don't want to propose something that is not within their radar at all. So when you are making proposals, at least align yourself and make recommendations on what's available already. With the African, with the protocol on AFCFTA, there is already a protocol on dispute settlement. And I think it can already give you the insights of what the African countries are thinking about. So I think that's what I want, I think this panel and also those who are yet to present to consider if your papers are to be impactful. Thank you.
So 2 seconds each. Do you want to respond, or you want to say that's fine?
I'll just respond.
Okay. All right.
Okay. My proposal for negotiation is there's nothing new about negotiation. What I said is that I give it as an example. My view was, what I was trying to address then was that at a point whereby you don't want to have an equal bargaining power between the investor and the state itself. And the investor, the state sometimes needs the investor more than the investor needs the states. So sometimes by default, because we are here in Sub-Saharan Africa, the fact of the matter is when an investor wants to invest in Africa, that African states need more from the investor than the other way around. So then the only way to ensure that the investor doesn't bulldoze to this country, the IMIC factor, is to have maybe a dispute resolution, multi-tier dispute resolution. It can involve even mediation, or those things people are calling exhaustion of raw economic, which sometimes I'm against because it might delay the case for the investor, but does not want. So it doesn't have to be negotiation. It is negotiation as you know it. It can be mediation. I'm just saying a multi-tiered layer, which doesn't involve going to the court at the first instance of happening of a default, which they claim. The last comment I had was on the commentator and my colleague here. My views when I was writing the concept of consent, I never so much focused on the specific about jurisdiction, about how to exit the convention. No, mine was just giving examples of various ways this convention can have the consent. I never structured it. It was not in a structure. So mine was just grappling with the idea of how can this consent look like? In fact, those were just all examples derived from various treaties. So for example, the one for ICJ, I never saw it, so maybe I should have considered it. The issue of when the convention fails to ceases to exist. So mine was just giving, that's the problem maybe with my paper. Mine was just giving examples of consent. I never said at what point is withdrawn or not given. That's all. Thank you.
Thank you very much for the comments. So I'm not sure how to proceed, but let me go from the last to the first. So thank you for your suggestion to look at the African dispute system. It's a very important aspect to look at, and I would consider it when I reform or work on the paper. One issue though I do have with the African court systems is one again is their fragmentation. But it's still good to look at it, but it's a good point to take. So it's something I would really consider going forward. As to Martin's point that the multilateral investment treaty issue has resulted to like failures, I'm looking at the time frame when this reforms or when this investment disputes were being discussed. So I would want to say that at this time, there are more developing countries, or particularly African countries, who are more knowledgeable, who are more interested in these issues, that maybe the negotiation of a new multilateral investment treaty might be feasible going forward. So I think it's not a very good stance to take that just because one has recorded failures in the past, then one should not try forward, make efforts to come up with a new negotiation or discussion. Also, I think we're also focusing on the fact that multilateral investment treaty should be hard law. There's also the soft law concept, and I'm bringing this concept in from like international taxation, where you have model tax treaties that regulate bilateral investment. So if we come up with a model tax treaty to regulate or to come up or give more clarity or uniformity to substantive issues in investment law, then it will be a good starting point, and then we'll build up on that towards a more stronger or harder law. And then I don't know if I got this question properly, that if we exchange, please correct me if I'm wrong, ma'am. If we exchange arbitrators and adjudicators, would it change things? At least that was what I heard. And would there still be need for looking at substantive issues? That's how I saw the question. And you also mentioned that fragmentation is not such a bad thing. So yes, I hear you on that, but that's one of the issues I have with the MIC, because despite the fact that it has its benefits, as Afolabi has mentioned, because it will lead to more consistency in decisions, and courts can build on the cases they have going forward. I still think that it is the MIC and the current ISA system that we have, there's really no much difference. So I'm still very strong on my position that looking at substantive issues is necessary and should be the first thing before we move into talking about reforming the ISA or ISDS system as we have it now. Thank you.
I have to thank you very much. I have to say that I also have comments and a number of questions, but given the time constraint, I'm not going to ask them. I'll just make one small comment, and that is because we finished on a note of substantive law, and I'm going to, and one of the things to note is that as far as the substantive law is concerned, actually, the newer treaties are beginning to address or balance some of these things. So there's a way in which you can say, a sense in which you can say, these things are being addressed. All right. So we shouldn't just be focusing, we have to realize that probably the older generation, yes, were imbalanced, but newer ones are coming. So in fact, there's a sense in which you can say even bilaterally over time, we'll have more balanced substantive regimes as well. It might not need to be a multilateral, even a multilateral would be good. Anyway, so I just leave that there. If you could help me thank the panel members. That's good. Take a break, or this next panel straight away. For a break. Oh, good. All right. Okay. Thank you. So So we'll come back at what time?
Yeah, we'll come back at 22. And then if they're starting like 4 to 2, then that's fine.
Okay, good. Okay, okay, that's great. Yes.
Yeah. Did you make
Is that all? Yeah, but no, but the reason they no, but you have to show up. Yes. Yeah. When you have the extended party to the extension that you want to the mix system. Yeah, that's what I was like. That's my. That you cannot be adjudicated as long as you are not expressly consented, which is important. That's very obvious.
At the first thing, my it's almost in the
Not a problem.
My feeling is what I wanted to indicate to the limited time was that it's almost similar
I'm sorry for you. Did you receive my program? Yeah, I know. Emma's speaking for it.
Okay. Hello. All right.
Okay. Welcome back, everyone, in the second part of our conference. So I am Professor Maleba Gemforere from the University of the Witwatersrand. So we are the host here, and it's good to have you and to be listening to you. So the first presenter is going to be Caitlin Mpofu. So Caitlin didn't send me her profile, but she is my student. So Caitlin, over to you.
Thank you, Prof. Good afternoon, everyone. So can you all hear me very well? Okay, great. So I'll be presenting on pursuing accountability for investors within the framework of the Multilateral Investment Court. So one of the things that I identified that was necessary for sub-Saharan African countries was to be able to make use of this potential multilateral investment court to be able to hold investors accountable for the negative conduct or negative consequences that some African states face as a result of investment. Okay. Okay, I'll just get started and then the slides will catch up if we manage to get that to work. So one of the concerns that have been raised with the use of ISDS and investor-state arbitration is its one-sided nature. And it's often been criticized, and this is rightly or wrongly, but the criticisms do exist about the fact that the system generally seems to favor investor protection over all other considerations. And because this one-sided nature usually manifests itself at the dispute settlement stage, where there's no argument about who should be doing what and who didn't do what, most people tend to blame arbitral tribunals for this occurrence. And as such, one thing that people would be looking to the Multilateral Investment Court to resolve is this one-sided nature of international investment law. But as one of the speakers mentioned earlier, is this something that the Multilateral Investment Court can actually resolve? We see that dispute settlement bodies, like a Multilateral Investment Court, are created by agreement, whether usually in a treaty. And that dispute settlement body is bound by the limits and the parameters that are set out in the treaties that apply to that dispute settlement body. So where parties agree that the substantive law that will govern their dispute is the law that is contained in IIAs, the dispute settlement body is bound to apply that substantive law to the dispute. They don't really have much leeway in that regard. So what we'll see is that even if we change to a multilateral investment court that is still bound to apply the same IIAs that exist today, we're still going to have the same problem where most people seem to believe that investment law seems to protect investors only. And this is because, as we know, most IIAs, especially the traditional ones, only have investor protections and host state obligations, but they don't have corresponding obligations on the investor, and they don't have corresponding rights for the host state. And the Multilateral Investment Court judges wouldn't be in a position to apply something to a dispute that doesn't exist within the framework that binds them. So in order for investors to be held accountable within the framework of the Multilateral Investment Court, there has to be a two-pronged approach to reform. One aspect is to reform the substantive law so that it creates a basis upon which the Multilateral Investment Court judges can hold investors accountable. And it then also need to reform the procedural aspects, and this is the dispute settlement procedures, so that host states can use that mechanism to enforce their rights that they would have newly accumulated through the substantive reform. So basically my presentation will illustrate what substantive reform can be taken to hold investors accountable, and also how the substantive reform will make reference to and will affect the procedures and the creation of the Multilateral Investment Court. So one thing that we'd have to start off is ensuring that there are investor obligations in some way or another expressly provided for in international investment agreements. And this is necessary because it forms the basis through which investor behavior can be regulated, and it creates a balance in the IIA between host states and investors in terms of rights and obligations. Now, one of the impediments, and this has been raised by other speakers as well, that has arisen or that has consistently been seen is the failure to agree amongst multilateral state parties on what should be investor obligations. Now, I think that as Maria, mentioned, there has been a lot of time that has passed since these attempts have been made. And we've learned quite a bit from the practice that we've experienced through the use of international investment tribunals. So I think there is a basis upon which there can be bilateral agreements between states in reforming their current IIAs to make provision for investor obligations. And we see a growing, although it's still a small trend, there is a growing trend in this regard. For example, the most notable that everyone talks about is the Nigeria-Morocco BIT. guarantee, but we do see that state parties themselves are beginning to recognize that there is a gap that exists in the international investment law framework, and we need to do something to fill that gap. Also, to address the issue on the difficulty of incorporating investor obligations, I would propose using the state's right to regulate. This would indirectly allow states to incorporate investor obligations within their national law frameworks. The state's right to regulate is already an accepted principle in international law, so that wouldn't be as contentious as trying to agree on specific investor obligations. But what it would do is that it would give host states the power to control and regulate investor activity at the national level without the fear of an international investment arbitration case being taken up against them. And this would be the so-called regulatory chill that a lot of states have been talking about. This would also be beneficial in the perspective of host states in general, in that it makes these mechanisms more accessible to the people who are actually affected by the investment, being the local communities. But then how do these substantive changes that I've been talking about affect the multilateral investment court? Firstly, by creating substantive obligations for investors and rights for host states, there needs to exist a mechanism through which these things can be enforced. Currently, with investor-state arbitration, host states can't institute claims, and they can only institute counterclaims in limited circumstances. So this would be something that needs to be addressed by the Multilateral Investment Court. Do host states have equal access to this dispute resolution mechanism that will ensure the protection of their rights as well? Secondly, in addition to equal access mechanisms, these substantive protections can be used to assist the Multilateral Investment Court in holding investors accountable. For example, through the use of doctrines such as the clean hands doctrine, where an investor would not be able to initiate a claim against the host state if they are guilty, either within the framework of the national laws of the host state, of violating an obligation that has been placed on them by the host state. This would sort of balance out the scales with regard to access by investors, but also protecting the rights of host states to hold investors accountable. Also, these substantive changes would empower the judges of the multilateral court to recognize that investors do have obligations within their investment and within the applicable law. And by so doing, they would be empowered to apply those investor obligations in dispute settlement, again, balancing out or giving them a basis upon which they can balance out the investment treaties and the international investment law framework. And by extension, it would place a mandate on the judges of the Multilateral Investment Court to weigh competing interests and effectively balance out those competing interests in reaching an equitable decision. So the question wouldn't just be, has the investor violated the FET standard? The question would be, in the context of the national laws of the host state and the investor obligations that are imposed on the investor, what outcome should we as the tribunal reach that will lead to an equitable protection of the investor rights as provided for in the IIA, but also of the host states' rights and the rights of their local communities? And I think the fact that tribunals would have this authority to balance out these competing interests would go a long way in ensuring that there's a balancing of the rights within the international investment law framework. Finally, and in conclusion, because I see that my time is up, I think it would be beneficial to sub-Saharan African countries as it would create a system which allows them to leverage investment without unduly compromising their socio-economic needs in respect of their citizens and the needs of protection and regulation of investments. It would also limit the competition between the national level and the international levels of governance, as both of these levels are working towards a common goal, ensuring that investors conduct their investment accountably, but also ensuring that host states create an environment that is conducive to investment. And if both of these, the national and the international level, are working towards that goal, you'll find that there might be less tensions between the national and international level when it comes to liability for investor conduct and complying with the same on the part of host states? Thank you.
Right, and we are now moving on to our second presenter. And that is Emma Chisove from the University of Botswana. And by way of just a short introduction, Emma is a legal consultant and a lecturer in the Department of Law at the University of Botswana. So Emma, let's hear from you.
Thank you so much. Good afternoon, ladies and gentlemen. When we speak about obligations from the previous speaker, one of the things that comes out clearly is the need to speak about corruption. So here I am, I'm going to talk about corruption and specifically the prospects for the Multilateral Investment Court being a tool for combating corruption, specifically investment corruption. And what are the lessons that we've learned from ICSID? And perhaps we can draw some inspiration from there to see if the MIC could be a useful tool in combating corruption. So this is how I'm going to proceed. I'll have an introduction and briefly look at the problem of corruption itself and the existing hurdles. The hurdles have already been looked at, so I'll not labor much. Then I'll go to the possible solutions and then I'll conclude. So we know very well of the duty-free case. Because of this, the question has become so clear out there to see what is it that can be done by institutions as it relates to combating corruption. So there are some questions that are raised when you're looking at the issue of corruption. The border between public and private law, including whether these tribunals have jurisdiction in the first place, if an investment has been tainted by illegality in the form of corruption. And also, to what extent should these tribunals be interested in examining the allegations of corruption? And in some cases, the parties, they don't even allude that there's corruption, but you can see that the transaction is tainted by corruption. So what should the tribunal do? And then, of course, all those things are informed by the substantive and the procedural rules. So the presentation basically wants to examine how treaty-based disputes involving allegations of corruption have been handled. And then we proffer some recommendations, perhaps to strengthen the envisaged MIC as a tool for combating corruption. The problem of corruption, of course, we see it at the inception and during the operation of an investment, but let's speak of the statistics. The cost of corruption is equal to more than 5% of global GDPs. That's about 2.6 trillion and exceeds the GDPs of most developing countries. And of course, it does increase the cost of doing business by 10%. So I think we're really interested to see that, find ways of combating this, this activity. And when we look at ICSID, the jurisprudence indicates to us some substantive problems that we have there, just the different ways in which the provisions have been interpreted. But mainly the last point is of interest to us, the use of the legality clause in barring jurisdiction. And this clause ignores the bilateral nature of corruption. It is two parties involved, not just one party. Of interest for us more is on the procedural issues, because I think this is what the MIC is really has to take a look at. And there are three things that I'll take a look at: the standard of proof, the investigative powers of the tribunals or the court, and the idea of transparency. So the standard of proof, we have numerous standards out there: balance of probabilities, beyond reasonable doubt, clear and convincing evidence, use of circumstantial evidence. And all these things have got implication on the outcome of the case. If you lower your standard, something that was likely going to be regarded as not corrupt could actually be regarded as corrupt, and vice versa. So the tribunals from our jurisprudence, they can just pick which one to make use of. And that is not good for jurisprudence on its own. And the question is, number two, can a tribunal just on its own decides to investigate occurrence of corruption when the parties have not even mentioned that or pleaded corruption as a defense or as a sword? How are we going to go about it? Transparency, we know that the proceedings are held in confidence, and we normally know of the outputs perhaps after, and in some cases we don't even get to know of the occurrence of such kind of a dispute. And worse still when it involves corruption, because we have high-ranking officials. They have an interest in keeping things under wrap, right? And number two, the participation of non-disputing parties, submissions by amicus curiae. The first presenter spoke about communities being affected themselves, and corruption affects communities. So can we also speak about participation beyond submissions of third parties, but at the amicus curiae themselves? So based on the contemporary framework that we have, my submission is that the court has limited prospects as an effective tool of combating corruption. Let's take note of the word effective. Okay, it could be there, but is it going to be really effective as a tool of combating corruption because of the varied legal text and the diverse standard of proof? But let's try to clothe it with some legitimacy. Let's try to give it some clothes so that it might become effective. So these are the possible solutions. I'll not labor much on the substantive issues there, but it's something that has to be looked at. Of course, the ideal thing is to have a multilateral investment agreement, and we have already spoken about the difficulties there, but of course we don't have to give up. The number two is to look at the BIT reforms, and I can say there have been some good inroads. Reforms, new generation of BITs is providing for corruption. Specifically, the example has been given of the Morocco-Nigeria BIT. Article 17 provides for that. And number three, which has not been mentioned there as a possible reform, which is really relevant for us, is to have a clause within the MIC statute that indicates the types of disputes that this particular court is supposed to hear. And we can borrow Article 25 of our ICSID, which speaks about an investment, and it should be an investment which has been made in accordance with the laws of the host state. But of course, there are problems to that as well, because we already have something which is similar to that, which is the legality clause. But to the extent in which we can make use of that clause to bar certain cases because of misconduct of investors, then we can say we can make use of it to promote rule of law. So let's perhaps retain that until we find better options within the substantive provisions of our different BITs. For the procedural interventions, I propose that the standard of proof must be aligned to the applicable laws. So let's look at the applicable law of each of the BIT in question. There have been a tendency to make use of these varying standards, but I've seen that there are two cases. One of them is the Kim case. It is coming up with a new way of doing things. It indicates that the standard that has to be used must be that which is recognized by the host state. So as a host state, my laws have been violated, right? And I make use of beyond reasonable doubt. So why should you now make use of balance of probabilities? Just follow the standard that I have as a state. And of course, this will implement the efforts of host states in enforcing its domestic laws. And of course, we clothe the MIC with the legislation, which has been one of the things that we've been complaining a lot. So currently, the standard that we are using, it really runs counter on how we deal with the cases of corruption, because it's actually a crime. It's not that form of other dispute, which is private. Number two, I propose that we need to equip the MIC with investigative powers, find solace in Article 25 of the International Chamber of Commerce arbitration rules. It enjoins the tribunal to establish the facts of the case by all appropriate means. We don't want the MIC to be complicit to occurrence of corruption by it closing its eyes. So we need to clothe it with these powers. But of course, we have to put in place some safeguards such as that there should be some prima facie presence of evidence of corruption. And of course, you inform the parties on the basis of why you want to investigate, and then you give parties an opportunity to respond. Number 3 is the idea of transparency. We need to have clear transparency rules within the MIC stage. We draw inspiration from UNCITRAL rules on transparency. And of course, there are certain things that have to be so clear from the onset. We need to publish or to make information readily available when a dispute has been lodged, and we need to know the sector in which these things involved. And once the proceedings have commenced, we need to include things such as the defense outlines. We need to have any transcripts of the hearings that were done. We also need to have access to the order or the award itself. But of course, we also need to incorporate some exceptions so that we can protect some issues such as confidential information or sensitive information. But the idea of protecting this should be at the discretion of the court, not the parties themselves, leading to say this is sensitive information, so don't publish it. The court has to exercise discretion. And of course, there's some guidance there on how you can exercise your discretion. Of course, I understand that the UNCITRAL has been challenged that model. But I think to give us legitimacy, and of course, transparency is important for people for consistency, and also it is important for other players out there to know that this is a dispute which is there and they can make their submissions. And number 4 is inclusion of non-disputing parties, amicus curiae. Before the rules of ICSID were revised, amicus curiae were not there, but now they have been put in place. So it's really beneficial because it protects public policy interest and can also assist in good decision making. And that actually brings me to the end of my presentation. So by way of concluding, I just indicate that we are having a piecemeal approach on dealing with the issues on corruption. And as a result, the successes are very limited. So we need to have a comprehensive way of dealing with the envisaged court. Thank you.
Great. So what I'm going to do now is to give the commentators an opportunity to comment, and then I'll open the floor for the questions. Okay. And over to you.
Okay, thanks so much. Can you hear me? Is the mic okay? Or do I need to?
No.
Can you hear me well?
Yes.
Okay, so I don't need this one. Okay, great. So first of all, I would like to say that I very much enjoyed reading both papers, and I would like to congratulate on that.
Sorry, can you hear her? No, they
Okay.
can't.
Like that? Better? No, this one is not working.
If you switch it on.
I'm trying. Just
No
looking
switch.
for the-
No switch.
Now it works. Okay, that better? Good. Okay, me and technology is not friends. Anyway, so I congratulated on the paper as well as on your presentations. Thank you so much. So I go on the accountability paper first of Kathleen. And really, you raise difficult issues, but I'm totally with you. And I think instituting investor obligations, and we see that coming, is really one of the fundamental shifts which IIAs are going to take. I'm pretty sure about that. If the system wants to survive, there's 3 elephants here. One is, one is climate change, one is national security, and the third one is investor obligations, which fundamentally changes the nature of the treaties, right? What I and I think what is interesting, and I think this is why it needs to be multilateral, and I could see this in the German discussion on the due diligence law. It's not that companies wouldn't like the due diligence law, but they said we need equal opportunities. So they're much more happy to accept that if it's regulated on the EU level. I mean, even though the EU level is not sufficient, it should be global because, they're facing, it's like in corruption. They wanted the treaties. the business wanted the treaties for equal opportunity. This is why the US pressured so hard on it. So I think it's important to take this up in a multilateral treaty. What you haven't mentioned in your presentation, so I'm also commenting on the paper and not on the presentation, is the multi-level governance approach. And you start off your paper with saying it should be, for example, the participation of local communities should be regulated. And there, I very much like the idea of the multi-level governance approach, and maybe not for that paper, but I think you need to extend it and explore it better. First of all, you need to explain to the uninitiated what's the multilateral governance approach. And then you can use it for many things. So you can, if you could draw a map on what comes in where, because, for example, the participation of local communities can be there, like it's in the zero draft of the investment protocol to the African Comprehensive Free Trade Agreement. But after all, the situations are so different that you wouldn't need it on the state contract level. So I would beg you to differ on which level that should be regulated and how. And the same thing concerns investor obligations and the national courts, which we have discussed before. Up to what point should that be on the international level? Up to what point that should be done first in national courts? Or for that matter, in home state courts? Because that is also what's in the zero draft. It's basically the home state courts. And the other thing is who exactly is involved in that governance. Again, here we have different models, like the French now in their droit de vigilance, they have civil liability. So you have the victims who could go for that. Whereas in the German law, it is basically not civil liability, it's fines, it's the administration, which would see whether the due diligence requirements are met or not. So if you can spell that out, I think that would help because it's different actors which are involved in the governance. Then I have a few comments. Before footnote 40, you say that arbitral tribunals have not significantly utilized the preamble when undertaking the treaty interpretation exercise. I think they have. They've done so a lot, just wrongly, in my view. They have just, basically concentrated on investor protection, whereas to me, it has ever been a secret how a state could conclude a treaty for the sole purpose for investor protection. If you talk to a political scientist, they would tell you that's crazy. They will never do so. Maybe the home states, but certainly not the host state. And it's on both. So it must be economic development, and investor protection is a means to another goal. So so you could spell that out. Then on page 15, you say, and I quote, inclusion of the right to regulate should not take away from the protections enjoyed by the investor. The multi-level governance framework advocates for a harmonious integration of the needs of all stakeholders into the investment regime. Yes, but of course it will take something away from the protected rights of the investors as it stands now. And I don't think that's not bad. It's always about, as Colin has said, we are basically dealing with administrative and constitutional law matters here. And what you do is delineate rights. We just shift the way how we delineate the rights. And that would be more easy, basically, if we change the way how we look at the preamble and what's the object of the purpose of the investment treaty. I very much like your chapeau idea. That's good. And then to the least restrictive means test, which you discuss. Here, of course, what's crucial is the margin of appreciation or the difference in the scope of review. And, I'm not sure whether you would really like to see second guessing of tribunals by the tribunals of very important decisions of the state, as we have seen in some of the Argentinian cases. Where, honestly, I don't see how a tribunal of 3 lawyers can second guess very tough economic decisions by a state without any expert knowledge being available to them. So I found this always very surprising. I think you should have a discussion how you connect this to the Business and Human Rights Treaty and the UNGP, the guiding principles, because I think that's important, and also how you might want to integrate that into MIC, whether it would be, for example, an opt-out annex, because not all states might be in, but you want, because of the equality of opportunities or the equal competitive opportunities of investors, you want to have as most states as possible inside. Then again, I'm also sending you my proposals and my comments to make this not too long. Then one more thing, when you say, well, when they no, that was, sorry. You have the proposal to make the firm's home state law relevant to those disputes. I find that a very difficult proposition. And why is that? Because if you ask companies to apply their home state laws, take labor rights, I think the first ones to love that proposal are going to be the unions in the home state. The developing state will surely not like that because, you know, for them, it's an opportunity to get investment, whereas from the home state, for them, it's social dumping. And we had this discussion in the WTO, and that was why they took the labor issues from the agenda. Now they're back on, but really on core rights. So I think you might want to take core ILO conventions, which you already find, for example, in the trade treaties. You could go further than that, but I think applying home state law would not be a good idea. Okay, I think I leave it here and I turn to corruption, which is one of my favorite topics. It's crucial for investment law regime, I think, and it's very topical. So I have no disagreement whatsoever on the suggestions for MIC, but I have just some suggestions for you, Emma, for extensions and things to consider. The most important for me would be to look at the incentives of the different actors involved and how those are changed and should be changed with your proposals. And you have a sentence in your paper which caught my attention, where you say corruption is to hedge political risks. Corruption to hedge political risk is usually led by public officials, while corruption for economic reasons is led by the foreign investor. I think you're basically referring to who has an incentive for the corruption. So my first question here is, what exactly do you mean that the official wants to hedge political risk? What's the sort of political risk then the official has? I mean, I can see the political risk for states from the state side. I'm at pains to see that's for the official who is asking for a bribe. But what the sentence did to me is that it hinted at we need to look at the incentives of the different actors, and basically, you know, and maybe I'm wrong, but I basically identified three. So you have the public official, you have the state, the host state, and you have the investor, and all of them have different incentives, and the question is how we can disentangle them. So first, I would say the public official doesn't care about a potential investment claim being brought against the state. He or she cares about being prosecuted and would weigh that against the benefit of the bribe, right? Unless, of course, they think within the investment dispute, the corruption is going to come up, right? So it depends if the investor may allege corruption of the host states, that will lead to criminal prosecution in the host state. So that would be basically in the probability calculation. Now, the state obviously doesn't want an investment case, and the investor wants investment opportunity and as a competitive advantage, you know, if the bribe is going on, because there are others who are not bribing, right? And of course, what the investor does not want is to lose investment protection. So how does that play out in the three problems you identify for dealing with corruption in IAL? As it stands, as you wonderfully set out, applicable law, standards of proof, and transparency. So let's go first to the applicable law. That's of course not uniform due to the lack of a multilateral investment treaty. But what again here I was wondering, and I was mentioning that before, is the interpretation via the 31.3c Vienna Convention on the merits, right? So UNCITRAL or the zero draft mentions the African Convention Against Corruption, but it could be the United Nations Convention Against Corruption. Why is that not being taken into account? As at least for interpretive, yeah, time means up.
Yeah.
Oh, okay. So okay. Let me be very quick. Or we discuss later on the procedural requirements. Can I quickly? Do I have 1 more minute? Yeah. Yeah. Because we have more time. You told me we have more time.
No, but we are running.
Anyway, short of time. Okay. The standard of proof. Just one issue here, and you say this in the paper and in your presentation. Depending on where you shift it, you have more cases where you find corruption and less. Then your proposal is to use the host state law. But the host state law will be law because states have basically put the international conventions in the so all the criminal laws have the bribery norms. That means it's always beyond reasonable doubt. So basically you propose beyond reasonable doubt, and the result is that many cases will escape the corruption allegation. So I found this somehow contradictory when you want to bring this in and you discuss the problems, but then you take as a result something which would really shut out a lot of cases. So I was wondering about that. On the transparency issue, I would ask you to think a little bit more about what transparency is really meant to do. And I'm all for transparency, but what would be the consequences of how you can prevent corruption? Is this reputational? What are the channels via which you would try to combat corruption? Is it reputational for the host state? Is it reputational for the company? Is it potential blacklisting on World Bank sites? If you could spell out those channels, I think that would enhance the paper, okay? Because then we can also better target it in a multilateral investment court. I stop here. I have some more site suggestions and stuff, but I send it to you. Thanks so much.
Right, so I can open the floor for you to have questions to the presenters. 1, 2, okay, now let me start. I'll take 1, 2. Professor Bangenberg. So I'm going to take 4 at the time.
Just a very short comment from my side, actually concerning your remarks, Anna. The first are currently generation of bids in force, at least from some NGOs, we call them, or they call them, some kind of neo-imperialism. But now you come and say, actually, if we put too many labor obligations and so on in there, it's kind of the same thing. So first generation actually is criticized because no labor rights, but then we're going a little bit too far, and then we're exporting our, well, called Western industrialized labor standards, and the critique is just the same. It's just as common.
Yeah, that's true. That's true. Yes, the lady behind.
Thank you. I think mine is just a comment for Kathleen's paper. I totally agree on your point that substantive issues are necessary before procedural issues. And I also heard when you mentioned that the new generation of BITs would take care of or can address substantive issues as well. So the one issue I might want to point out, and I think you also mentioned the Morocco-Nigeria BIT. So one issue for me there is that this BIT was concluded between countries that have similar level of development. So for these new substantive or new treaties you're talking about, do you also want to consider the power asymmetry when you are looking at two different countries at different development stage? So let's say developed countries and developing countries. So that's the comment I have.
Then in the middle, yes, I'll take 3 gentlemen here. So that would be 5. And then we can get responses. But I always say, I mean, for you, I always say that as a presenter, I would rather take more from the floor than responding, well, that's me. Okay, yeah, so let's hear.
Thank you. So my comment is to Emma. Part of the question I had has been addressed by the commentator. But when you're talking about corruption, I was just wondering what scope of corruption you have in mind. Do you also perhaps want to consider money laundering and maybe a situation where there is a collusion between the state and the investor such that maybe none of the parties would want to disclose the corruption?
Okay. Next, yes.
My question is to Kathleen. So the sense I get from your presentation is that for the MIC to be beneficial for Africa, we need to do some substantive law reforms by concluding more balanced BITs. But what I want to find out is whether you have also addressed your mind to, let's say, treaty interpretation, even of the existing treaties. So for instance, if you look at Article 31, paragraph 3C of the Vienna Convention on Law of Treaties, it allows adjudicators to look at other rules within the international legal system that may be applicable between the parties. So to what extent have you considered that treaty interpretation, especially using the principle of systematic integration, could be a way of reading existing treaties in a more balanced way that would advance the similar goals as you are suggesting?
Next.
Thank you. My question goes to Emma. I think part of it was also addressed during the commentary. I just want to understand when it comes to the home state evidence, applying the home state evidentiary rules, does it then mean that you then are going to have a trial in the investment dispute? Is it going to turn into a trial? And if it does turn into a trial, what is the effectiveness of that action? Because that judicial body will not be able to, for instance, effect a custodial sentence if an official or an individual is found to have committed corruption.
Okay. I think there were 2 more hands in the middle. Let's take as much as we can.
Thank you. Questions for both presenters regarding the accountability. Sorry, the accountability of investors. It's an idea floating around. It's not specifically African revendication. It's growing, and it comes together with the idea that the stakeholders, and including the ones who have indirect interest in the case, should be heard. So you have a whole context which is very favorable to these ideas currently in the more general frame where it's about rebalancing the whole system. So I found what you said consistent in this regard. But I think the broader context is important to bring on board in the study. Regarding corruption, and more generally, what has been said now regarding interpretation and the use of Article 31.3c of the Vienna Convention. Of course, it's a good tool, but at the same time, adjudicators, whether arbitrators in the current system, but probably adjudicators sitting in an MIC, would not use this argument on their own initiative. And we have to keep in mind that all adjudicators react or study a case in view of the arguments raised by the parties. And it's not only in investment arbitration, it's everywhere where you could look at the WTO dispute settlement, the ICJ, and the other judges. They do not bring on board Article 31.3c if one of the parties has not brought the argument. And it's true also at the European Court of Human Rights or everywhere. So you have to take this into account also. This provision is very broad, but at the same time in practice is never used spontaneously by judges. So this is a point to be taken into account. And regarding corruption, all the same, this idea that judges could tackle the issue spontaneously, proprio motu, as you seem to have said, or I misunderstood. I don't see how arbitrators or judges of MIC could raise the issue on their own motion. They need at least one of the parties to bring the argument. And in addition to that, if this party doesn't bring any evidence, any exhibits in support of the allegation, it will not go very far, whether at the MIC or before an arbitral tribunal. So there is a whole context, and the setting up of the adjudicatory discussion is important to take into account. And it leads me to a remark regarding transparency. Of course, transparency will reduce the opportunities for corruption, but corruption is also a state of mind in the sense that even if the system is perfectly conceived and very transparent, people who want to fraud will fraud. So once again, it depends whether the issue is brought before a tribunal or not. And of course, arbitral tribunals or the MIC could not tackle the criminal aspect of corruption. But nevertheless, they can draw consequences from a situation of corruption in terms of their conclusion. So I think it is good to go in the directions you've proposed. Thank you.
This side, are there any questions from this side? Okay, so, all right, let's take this one. The mic is coming over to you.
Thank you. I think I have one question for Kathleen. When it comes to investor accountability, one option that we are seeing in the recent investment agreement, at least those signed by African states, is initiating civil actions before host state court and tribunal. But we also saw that those kind of actions can lead to investment cases against those states. So my question is how maybe you think this multilateral investment court can address this threat, if I might use that word. Thank you.
Do we still have any questions from the floor? All right, so I will also pose my questions so that when they respond to everybody, and then we can move on to the next session. So for me, I mean, I think it's for them and also to those who have presented earlier on. And I think this came out from our discussion with Professor Brandenberg. No, Brandenberg was my Bungenberg, yes. Yeah, that it would be interesting for you to actually indicate that, or to at least acknowledge that there is no mandate for the proposals you are having right now about the substantive issues and so on, because the mandate that countries are grappling with right now is for the Multilateral Investment Court. And I think this is what we are expecting to hear, like, you know, what you bring to the table as African scholars. How do we shape the Multilateral Investment Court based on the mandate that we currently have? Because what you are proposing about the substantive law issues to be brought in, this would be a new issue, all right? But currently there is no mandate. So you need to acknowledge that. And again, I think what we also have to consider is, I mean, this is for me, I mean, in my writings, I always bring an argument that I wouldn't be happy that we have an African way and we are being treated differently. I mean, the world is one, you know, we are interconnected. So how do we as African countries play the game to our best advantage? Because we cannot be treated in a special way and then expect to participate in the global value chains. Otherwise, if we want a special treatment, we might as well watch when everybody else is playing the game. So really for me, I would be interested to hear all of you to talk about how we can shape this Multilateral Investment Court to our benefit, okay? And so this was a general comment. And to both of you, Emma, I would start with you. It was an interesting paper to listen to. And I was triggered by you here, you know, talking about the standard of proof. It's a very rich topic on its own. And I think that's, if you were to contribute to the discussions around the Multilateral Investment Court, I would say that just hold on to the standard of proof and hone on to it, because it's really a rich discussion that in the WTO also, there is a good literature on that. And one person I know who has written a lot about the standard of proof, but this was the WTO context, is Professor Matthias Wesch from the University of Zurich. So you can look at that. And I think your contribution would be phenomenal, all right? And then to Kathleen. Well, I didn't see Kathleen's paper, so okay, never mind. Let me give you an opportunity to respond, because now I can't see what I have written. I think, Kathleen, the issue was about the substantive issues that you are raising, that the court must look at the substantive issues. And the comment I have made as a general one equally applies to you, that you must at least acknowledge that currently there is no mandate. And so maybe the innovation or the addition to literature would be, how do you tie the substantive issues to the procedural issues? Because at least you must say that even though the mandate is currently the procedural one, the establishment of the court, but for it to function properly, we must at least look at these issues. So in doing it that way, you would at least have indicated that there is no mandate, but what we are looking at right now will not be sufficient for 1, 2, 3 reasons. And it must be clear why you want to bring in these other issues. So I give it to you now. So I give you, we must start the new panel so I give you 3 minutes to respond. Okay, so we start with, who do you start with, Caitlin? You can start 3 minutes just to respond.
Thank you to everyone for the comments. I will take those into consideration. I think they make for good further thinking on my paper. And then just to answer the question on Article 31 of the Vienna Convention on the Law of Treaties, one thing I was running away from is sort of giving tribunals the discretion to determine how they want to interpret international law. Which international law are we going to apply? What if the tribunal doesn't agree with you saying we want to apply this international law as opposed to this international law? And I think it just perpetuates the problem of open-ended provisions that provide tribunals with very wide discretion to determine how they think the parties, to determine what they think the parties intended, as opposed to the parties themselves being very specific about what we're intending to do. We want to have obligations for investors in this way, as opposed to saying, we might argue it before a tribunal and see how it goes. So I think that was, while it would work in theory, it wouldn't work all the time. And I think that's just what we're trying to run away from by having it expressly included. And then the issue on the initiation of civil actions and how then that could be a threat within a threat of an arbitration claim. I think this would be addressed again with incorporating rights for the host state. For example, if the host state has a right to regulate in a certain area in the public interest, and part of that regulation is the imposition of liability for failing to comply with whatever the regulation is. When a dispute comes up, the host state has a basis on why they did what they did. We did this because we have a right to regulate, and we've regulated within the confines of that right. So we cannot be held accountable for this particular thing. But then one thing that would be important to note is that host states themselves, they need to know which areas do we want to regulate in? What are we allowing ourselves to do? And what are we not allowing ourselves to do, so that it doesn't encroach too far into the investor obligations, and then those obligations are rendered illusory because we've given such a wide range of powers to the host state to do whatever it is that they want to do. Yeah.
Okay, thank you. Well, thank you for the comments. I appreciate them, and I'm going to incorporate them. I'm not going to respond to the questions. I actually have a question for you, because of something that I actually removed from the paper, because I've been wondering whether to include it or not. As the idea of whether judges should report to the relevant authorities corruption, which they have unearthed during the proceedings. It's that's something that I want to pick your brains on, because I removed it because it was part of the procedural issues there.
Can I have a quick word on that? I didn't comment, it's in my comments, but,
okay.
But I took it out due to time constraints. But I thought, you know, what is the incentive of the state to invoke corruption? It is, if there is an all or nothing approach, that they escape jurisdiction, right?
Yes.
So you want to make this credible. And one thing could be that they must show that they have instituted national proceedings against that public official. Now, that could be the case if you have a change of government, if you talk about political corruption, otherwise not. But if the state is not pursuing that public official before its national criminal courts, the case to say we invoke corruption is weak. Okay, so that is something you could do. I think instituting a duty for the arbitrator, not for the arbitrators, for the judges, to report to national authorities, I would think that's a duty of the state. You know, the people presenting the state, saying, okay, if the international judges think there's a serious case of corruption, then as a state official, at least in Germany, you would have the duty to report that to the police. So that's, in a way, it's there anyway, not from the international judges, but from the people representing the state before the international court. That's Germany. I don't know how that would be in African jurisdictions.
Okay, all right. Thank you. And now we are moving on to the last presentation for today, and that's our facilitator, Martin.
That's a special step for organizing.
He will get that.
Maybe later. And this should be working. No, well, yes, I do, but originally another scholar was going to give a presentation, but unfortunately, because of a family tragedy, she can't be here. So yeah, that's obviously, that wasn't a nice email to read, but look, it's the last presentation. Stay with me. It's a little technical. You can see from the title there. I'll start actually by giving some thank yous. My two partners, Emmanuel and Jonathan, thank you so much for putting this all together. It's been wonderful. I also want to thank the kind of invisible workers in the process. Magda, who works here at the Mandela Institute, like just things you see around here happen because she's working so hard. And Sithan, thank you so much for putting together all the technical stuff for us. That's wonderful. And I'll give some apologies first to August Reinisch. You must have picked up the paper and thought, no, why did you write about this? And perhaps I'll give an apology to Anna Jobin-Pret because, well, you'll see. So that's the topic. I changed it about 2 weeks ago. Reason being is this reason here. I picked up the, this is the report from the latest meeting of Working Group 3. It comes from UNCITRAL, of course. That's the report we're going to look at. And I was reading through the report. I came across this part here and I became really very excited because it starts talking about damages and compensation, which is something I'm quite interested in, but I didn't think it was part of the mandate. But anyway, they write this in the report. They say the way forward is this. Considering the support expressed to continue work on the assessment of damages and compensation, the working group requested the Secretariat to draft text, hence my apology to Anna, has asked them to draft text, and I'll ask you to come down quickly to the bottom here. It was noted that the draft text could address issues relating to, among others, causation requirements. There's a very small fan club of people who are interested in causation requirements in international investment law, and I'm the only member. So I thought this is an invitation for me to finally write a little bit about causation, and you're going to see if you're standing in the position of potential African state going to be claimed from in the future. I hope my research might be somewhat interesting to you. The proposal is this one here. The inclusion of provisions in the treaty creating the Multilateral Investment Court, directing the adjudicators to test for fault aspect causality. I suspect you understand everything until you get to the final 3 words there. Don't worry, I really hope that by the end of it, you'll understand everything. That line hasn't quite come out properly, but that's okay. Our basic question is, what is fault aspect causality? I think, like, on a theoretical level, I can say this. It's testing whether the fault aspect of the state's conduct is causal vis-a-vis the investor's loss. You probably still say, what does that mean? Sorry? I hope so, but I'm not convinced that they are. They've got to look at the fault aspect. Yeah. So perhaps I'll go through a couple of examples and I think you'll get it immediately. So we'll start off with a non-investment case because I think it illustrates the idea really well. You have a pedestrian versus car driver case. It's a pretty simple one. The car driver hits the pedestrian. The result is a broken leg for the pedestrian. Speed limit was 40. The car driver was going 50. So you know immediately that there's a bit of a problem here. If you are a lawyer for the pedestrian, you're going to be asking yourself, hopefully, what is the correct causation question or the causal question? You might think it's this one here. If the car driver did not drive into the pedestrian, would the pedestrian have suffered a broken leg? You can probably put it in more simple terms. Did the fact that the car driver drove into the pedestrian, did that cause the injury? I mean, obviously, yes, but that's definitely, well, in my opinion, although not everybody shares this opinion, that's not the question you want to ask. The question you want to ask is this one here. If the car driver had driven at 40 kilometers per hour, would the pedestrian have suffered a broken leg? All right, what I'm trying to do is like isolate the fault aspect, because the fault aspect is the fact that the driver goes 10 kilometers per hour over the limit. And if the accident still happens at 40, there's no causation. And you might think, well, how could it possibly happen? Well, for example, you know, the pedestrian just stepped in front of the car at the wrong time and the accident was going to happen anyway. So that's the question that I want arbitral tribunals in the future to ask. And unfortunately, I have to say they don't, there's not that many examples when they do. I think they definitely should though, but here's a case where they really should be doing it. So we'll take a simple case, investor versus state. The state reduces a subsidy that it pays to the investor. The bottom line is that the investor's investment is then devalued. So there's nothing too complicated there. It's decided by the arbitral tribunal that this reduction of the subsidy was a breach of the rule on fair and equitable treatment, which is I'm picking up on all of these Spanish cases recently. All right. What's the causal question? Is it this one here? If the state had not reduced the subsidy, would the investor have suffered loss? No, no, no. We do not want to ask that question. That's not our question. Our question is this one here. If the state had acted fairly and equitably when it reduced the subsidy, would the investor have suffered the same loss? So for example, if the subsidy was 100 ducats a month and say the state actually reduced it to 60, but it would have been fair to only reduce it to 90, then we ask, if the state reduced the payment to 90 ducats per month, would the investor have suffered the same loss? And potentially the answer is yes, because the investor was only just floating above water, was only just profitable, and the subsidy changed and it went insolvent anyway. So you can see in some situations, depending on which question you ask, it can make a huge difference. So give myself a tick there. Yes, that's the question that we need to ask. If hopefully at this point you have a bit of an idea of what we're talking about, this fault aspect causality, can I try to convince you it's what we should be doing all the time? Well, we arbitral tribunals should be doing all the time, or us, the people in the community of jurists of international investment law. There's actually more to the argument than this, but I thought I would pull out my trump card immediately and say, this is the best reason that I have. You can apportion compensation according to fault. Ooh, I didn't want to get into technicalities, but I have to, I'm sorry. So what I'm trying to do here is that when an arbitral tribunal, well, I might just go straight to my example because it's going to help us a lot more. So again, state reduces subsidy. It's at 100 and it goes down to 60. That is unfair and inequitable. We know that the fair and equitable reduction would have been 90. So what I say is, in this situation, rather than giving the investor compensation for its losses caused by all of this reduction, the 40%, the 40 ducats, all I'm saying is that we should only give the investor losses attributable to the unfair and inequitable part of the state's conduct. So the kind of additional 30, which would mean the investor only gets 75% of the compensation that it ordinarily does at the moment. I hope you're still with me. Yeah, good. It is the end of the day. Many people have been on awful planes, breathing in very dry air. But the bottom line is that at the moment, if an investor proves a breach of fair and equitable treatment, they get full compensation for all of their losses. And I'm saying, no, you only get compensation for the losses that you can tie back to the unfair and inequitable part. And if you're wondering why you should get so excited about that, is I think it's like this. A lot of investment treaties now, they say no unfair and inequitable treatment, like essentially, but on the other hand, they're telling states you have the right to regulate. So they're kind of encouraging states to go about regulating, but they know that if they go too close to the side of the cliff and just go over, it can be a very long way down to the bottom. I'll go back to the microphone. What I'm trying to say is to states, look, if you just go a little bit over the edge, I'm going to catch you at some point and you won't go crashing all the way down, because I'm only going to say this: you get losses for what the state has caused through its unfair and inequitable conduct. So hopefully that might get you on board. If you are on board, or you're open to the idea, you're probably thinking, how do you kind of go about all of this business? And I have to admit, it is, this is the rather complex part. And when I was writing the paper, I started cursing myself, saying, why did you write about this again? And I thought August Reinisch was going to kill me at this point, but he hasn't yet. So, no, because this is rather difficult. I'll just go through the most important steps. And the most important step of the most important steps is this one here. You need, well, this idea of testing for fault aspect causality only works if you have a rule with a fault element in it. So again, you have to ask, well, what is a fault element? It's basically an element in a rule that describes state's conduct. Again, some things are just easier to explain with examples. So fair and equitable treatment is like the perfect example. Describes the conduct that the investor should expect. Full protection and security, free transfer of capital. What about expropriation? Actually, no, it does not have a fault element. I might change my mind on this in a couple of weeks, but at least my opinion is this now. The rule on expropriation is so simple. It just says, do not take investments. It's only concerned with consequences if there is a taking of the investment. The rule is not concerned on how that happens, the quality of the conduct. So I would say this is, you can't use it with expropriation, but I woke up this morning and I thought, and I've also, my time is out. I thought I might change that, but we'll see. I'll be very quick here. The other thing you have to do, of course, if you are the arbiter tribunal, is to reformulate the fault-worthy conduct. So you decide that conduct is unfair and inequitable, and now you have to try and reformulate the conduct into its fair and equitable form. I'm not that worried with that. Adjudicators have to go into the business of adjudicating. They have to use their discretion. I'm actually fairly comfortable with that. So look, if you don't mind, I'll jump to the end here. I hope that I've introduced you to the idea. You know what it is. You're open to the idea. If you are, then it would be a question of, do we include any treaty text in there? I had a go at drafting some. Looked at it this morning again and said, no, I want to change it, but I leave it up there. I'm somewhat anxious about it, but look, if it is something that states want to do, it might be something they can do, because compared to the rules on international obligations or substantive obligations, compensation is rather small, and the rules should not differ across treaties. So it might be something that's worth looking at. Thank you so much for your attention.
So now we're going to give it to Prof. Reinisch to give a comment on your beautiful presentation.
Perfect. Thank you very much. Well, first, let me say thanks to the wonderful conference that we are having here, to all the papers that we have been presented today, and the exciting presentations, and the particular pleasure I had reading this paper. So Martin, don't worry. All of my anxiety was limited to 24 hours since you sent it yesterday, so it's okay. A few words, because unfortunately we heard that there was another presentation planned by Pritilar, And it was a very interesting paper, which nicely complemented the second paper that we heard here, also on corruption and political instability and links to the International Tribunal. And of course, I'm happy to give some written comments to her paper. But I also wanted to acknowledge that that was interesting to look both in regard to what kind of remedies, what kind of consequences could a court tribunal draw from finding corruption. And what I found went beyond what we've discussed here in her paper was also how to ensure that the adjudicator itself, a regional multilateral investment court, can be as good as it gets, or as far as possible, immunized against corruption and bribery. So I found that interesting. Now, returning to Martin's paper and excellent presentation, I think everyone has been convinced. Of course, if you tick and if somebody says, no, this is wrong and the other is right, that must be so. So the visual aids are really helpful, I guess. My good friend Jarrett told me, or no, he taught me actually, when I first joined the commission, you say two nice words, and then for 20 minutes you slash the entire report and you tell your colleague why this was all rubbish. I'm not going to do this. I do 1 minute. No. A few critical remarks, because that's really the whole purpose of the exercise. I enjoyed it. I think maybe as a very start, and the message was clear. Thinking about compensation and combining it with I think you mentioned it, but it was implicit, this all or nothing approach, the appropriate one. Couldn't it be more nuanced? What really is due? What is the harm suffered? What possibilities do we have here? And I think that is really worth to think about and to discuss. In the paper, I struggled a bit, and I think I informally told you already over lunch, with some of the definitional aspects. You started out saying, well, I'm proposing a 3-step test which goes about beyond the normal usual 2-step test on causality that is prevailing in current practice. And I was wondering, 2 or 3 steps or 4 steps, how many steps? So what is that? I think what I understood from this first definition, you say that the currently prevailing 2-step test, and it links us to the car accident example. One is the factual causation, the sine qua non test. I mean, would that have occurred absent the act that causes here the car accident, or the broken leg, as you said, or something else? And then something interesting, which I think should be elaborated more. You say, in addition to this factual causation, there is also something like cause in law, having regard to various normative factors. And I was very curious. So what is this? As a continental lawyer, I was thinking about adequate causation. Is that what in my legal system, in many legal systems, probably we are trying to reduce all the factual causation to something that is in a, and here it may depend on different legal systems, some kind of foreseeable, logical connection. I'm asking more whether this is what you consider to be the various normative factors. Now, then it comes to the issue, and that's where I'm still struggling, even after your presentation. You say you want to adopt a fault aspect causality, and you talk about it should be guided by fault. Now, from my understanding, we can talk about either purely wrongful act leading to responsibility. That's the approach in the ILC articles. We're not talking about negligence, intention, anything that was discussed maybe 60 years ago in the ILC, but by 2001, it was very clear it's wrongful acts. And fault may sometimes come in on the primary level if there is a due diligence obligation or something like that. So fault, and here again, I think the paper would greatly benefit. Maybe it's just a definitional issue that we are having. Are you really thinking about something we would normally describe as from intention to negligence? Why do I stress this? Because some of the examples, when you talk about the car driver, you say, what made what is the fault-worthy aspect? So I thought, well, probably he was negligent when driving, but then no, you say, because he went over the speed limit, and that is a wrongful act. So it's just, yeah, you get the message. And later on in your paper, you talk about that the state is legally responsible for all consequences flowing from its unlawful conduct, as opposed to only consequences from the fault aspect. So then I thought, well, maybe he's making a difference. But you're not really spelling out whether fault is in the traditional understanding of something that you can actually say a state, well, not only is it wrongful, but it was also faulty, or whether you could reduce it to unlawful. Now, if you reduce it, then I wonder whether, for instance, the suggested text is working. And I also noted this because I thought it's a very good idea to draft language to say, how does that work, the theory? How can we implement it? Because in working group 3, ultimately we are considering alternatives to current formulations. There you say a remedy to the state's breach of an obligation containing a fault element. So that again suggests it's more than wrongfulness. And that needs to be clarified on a conceptual level. And because of my time limit, I'm not going to talk about the car accidents, but maybe we can come back to that. That leads me to a third point, what you summarize in your paper and what you, I think, very well communicated to us, the why of the fault aspect causality. And I think that's where you should continue thinking this idea. Is there a possibility of finding some criteria that could limit the amount of compensation ultimately adjudicated in these cases? Now, I also struggled a little bit with, you have one paragraph, I think, on what you mentioned also in the presentation, responsibility. Where you say, responsibility for expropriation. And I agree with you that as opposed to fair and equitable full protection and security or others, which are normally standards that are breached and therefore trigger responsibility, yeah, expropriation as such is not unlawful. But then I wouldn't say it will result in responsibility. Rather, the primary norm is you are entitled to expropriate if in due process for public purpose, etc., including compensation. I mean, that's part of it there. Only if these legality requirements are not fulfilled, then there's responsibility. But again, it could be a terminological problem. It might be something to be taken into account when talking about the issue of can we find here maybe also some parallel to what you're suggesting that leads us to reduce the amount of compensation, because as we all know, there are all kinds of interferences in property in a broad sense. And at some stage, suddenly it's expropriation. And all the way up to the, I don't know, 60, 70, 80%, it's fine. But then, so maybe one could think about that also introducing it. And is my time up already? No, I will be the only commentator not exhausting the time because I have one more minute. And let me just conclude. I think it's a very appealing idea, this thinking about what standards can we use to limit the amount of compensation. But as I said, I'm not sure, and I think it will be very difficult to make that workable by differentiating between harm that results from wrongful, faulty, non-faulty acts. So I think it's really on this level where there needs to be some further work. Thanks for an exciting read and very good presentation.
Thanks a lot. So I'll start here with me. Let me start with you, Anne, and then, yeah.
Thanks so much. So I just want to say I'm joining the club. No, I wanted to say something more. I haven't read your paper, Martin, but I think the issue of overcompensation taking place, setting wrong incentives for the investors is a real problem, and I would take it from there. There are two issues here. You tackle one. One is one is this sort of causality, but I think there are two other issues here. One is contributory fault, and the other one is loss of income in, for example, economic crisis anyway. And my most favorite case study in this is the CMS case, where they went bust. Why did they go bust? Because they took their credits in dollars and not in pesos. So I've talked to all my friends working in banks and project finance. I said, would you ever give money to somebody working in Argentina or any other unstable country and taking their debts in dollars instead of the national currency, even though they had a currency, it doesn't matter. Doesn't matter. Said, no, we would not do that. That's bad business judgment, which the tribunal never took into account. More important in this case, they never took into account what would the income have been in a severe economic crisis, where the first thing which goes down is energy consumption. They did as if Argentina would have growth rates of 6% per year. And that was how they calculated the damages. So this sort of contributory fault in not trying to get insurance, because also, I mean, there's no question you can insure your currency risks. And you're supposed to do so as a good, if you do good business judgment. If they don't do it, they shouldn't get any compensation. And this was totally lost on the tribunal. And it's lost not only on the CMS tribunal, it's unfortunately lost on many tribunals. So I think there's much more to what you do here, and I would try to extend it. And I think I stop here. Maybe just one little thing. I would like to see your proposal, how you situate it to the proposal of Eisbeth and Bonilla on the Pareto efficient damage calculation, which was in GEL and got the prize, this annual prize, the John Jackson Prize. So you might want to have a look at that. And then one thing on, and then I stop. On August's car driving thing, it's both about strict liability in a way. So you need to look at that. I think you need to discuss it because those questions would come up, because car driving is of course strict liability. So I stop here.
Okay. Thank you. And Emma?
Oh, I'm now confident with the.
Sorry.
Where do you put it? It's fine, right? Oh, you can hear me. I'm now confident with my question.
because I thought at first I did not get the concept properly there. So my question has been partly addressed. It's just speaking by anyone speaking about contributory fault. In my, I was thinking of contributory negligence. Is there a way, does it relate somehow, or does it differ? And perhaps for us, I think it's so useful in the context of African countries, whereby we've been crying of overcompensation. And now when we have this faulty based system, so to speak, it will do well. The question that I have is, can we also use it in the context of investors' conduct? The issue is addressing the state's conduct, that the state has done this. Is this something that can be extended to the conduct of the investor? I ask it in the context of corruption, because one of the things that we're asking is that the party, the investors done A, B, C, D. So can we also draw some lines there to say your conduct is really unlawful, it is faulty in this element? And as we go now to the compensation which is payable, could we also look at your conduct and say, therefore, this is how you should be compensated? I don't know, perhaps I got the concept wrong, but just wondering if it can be extended to the conduct of the investor.
Yeah, great. Yes.
We need a mic on that.
I think you need, because it's being recorded.
Yeah.
Thank you so much. Just two short remarks. One, this problem I also had with some of the other presentations. Question is this more thoughts on the general development of international investment law, or how does this reconsideration actually fit under the conference theme, in how far is it beneficial for the Sub-Saharan Africa? This one question. Other question, I think I don't agree, and if I understand August correctly, it's probably the same direction, especially regarding expropriation. So, I mean, there are a lot of causality questions. If I don't pay enough compensation, we are directly and unlawful. Or the more recent developments regarding indirect expropriation, and also with the formulation of, for example, the CETA text, where you have some kind of proportionality elements in there, and also indirectly you see causality in there, because only in rare circumstances you end up at an indirect expropriation. Well, first you have to describe these rare circumstances that then finally might lead. So I would not exclude the topic of expropriation at all.
Right, and then lady there, and then, yeah.
Thank you very much for that presentation, Dr. Martin. I also struggled to understand, and except I don't understand, the example you gave. One of my confusion has been addressed with the contributory negligence kind of thing. And then I'm also thinking, what if it's like force majeure, you know, like giving the example of the car that you gave us. Okay, the driver is at 40 kilometers per hour, and then something happens, maybe a branch falls or something, and then he, you know, hits the other man. So taking it in the context of what we're talking about, where it's not the fault of, you know, the investors, I mean, the host state, because that was the context you were coming from. So what if they've done everything they're supposed to do, and then something unexpected happens, and then, you know, the issue of fault, the fault aspect, causality is now to be determined. That's one part. And then I'm thinking, if the multilateral court has to deal with this, who decides, well, I know it's work in progress, but you may need to think about who decides, who decides what determines the cause aspect causality. Which of the adjudicating persons decides this, because otherwise it's going to take a very long time, and part of what the MIC is trying to cure is time. If it takes a long time to determine whether there is cause aspect causality, whose fault is it, and all of that, I think it's going to eat into the time of the adjudication. Thank you.
Okay. Then I saw one hand over there.
Thanks very much. I would like to take my hat as the Secretary of UNCITRAL off, because it's the end of the day, and because I find this discussion fascinating. And tell you, Martin, that I joined the club, not through all the reasoning, because I stopped somewhere where August Heinisch also stops. But I think that it's a very valuable effort that is going to be very important in the context precisely of the decision by the working group to take up reforming, as part of the reform of investor-state dispute settlement, reforming the calculation, the assessment and calculation of damages and compensation. So please don't stop here and don't be discouraged, because we tell you that we're not exactly sure about, how you can safely say there is a violation of fair and equitable treatment and this is a fault, but that I think the actual exercise that you're embarking upon is going to be very, very useful, because we have to get out of the current system, which doesn't provide guidance to the arbitral tribunal on how to exactly do what is required, which is to say, taking all the factors, and there are many factors, and there is proportionality, and there is, August has mentioned, Anna has mentioned, all these elements, and then you come to the bottom line, and at the bottom line, you have one expert who says it's worth 0, and another one who says it's worth 3 billion. And the arbitral tribunal has to make a decision without having further guidance. And so that is where real important work is going to come from, all the contributions you can make to Working Group 3's deliberations on this topic, because we have to get out of the discounted cash flow method, which is the only one that works and which takes into account only the aspects of the investor, not at all the part of what the state brings to the table, and how, for example, you're talking about the Spanish cases. The question is, faced with an economic crisis, who should shoulder the causes of this, the consequences of this economic crisis? Has the investor be kept immune from shouldering his or her part of the crisis? Should it only weigh on the citizen of the country who have to then compensate? So all of these aspects have to be taken into account. I'm very glad that we're discussing this here in Africa, because the fight to have this topic part of the mandate of Working Group 3 was led by South Africa, by Nigeria, by a number of African countries who said, this is key in the reform of investor-state dispute settlement. If we don't do that, we will have missed completely or partially on the reform of a system. So thanks very much, and I joined the club.
Yeah. Then Paul, I saw your hand. Okay. Right. So I have the last one. So the last one, I think, which, well, I think this works. Yeah. The last one, which I think I have, and also which ties in with the previous presentations, is about the standard of proof Are we gonna go the criminal route or the civil route? Because if we're gonna be using fault, then obviously the standard is gonna be much higher, and investors might not always. I think it's gonna be murky if we use that one. So I think we need to find another terminology to replace that fault. At this point in time, I don't know exactly what we can use, but I think let's try to lower the standard, because the fault one is a bit higher of a standard. So I joined the club. And then for now, this is a general comment, and I think this is how I would have loved to see your papers. So this is an example about the methodology, the style of looking at the problem we are looking at. So what Martin has done was to tell us exactly what is happening at the working group 3. So at the working group 3 right now, we are looking at the reform of ISDS, all right? And then there are a number of issues that are being looked at the working group 3. And then he picked one of those, and which is causation. And then he is bringing in his ideas about how to tackle the issue of causation. So where I'm getting at is, for you as African emerging scholars, I was expecting you to say, this is what is being looked at the working group 3, and I pick the issue of the standard of proof. And I think as Africa, this is how we would like this to pan out. So in this way, we are staying on course, all right? But we are bringing in our ideas. So bringing in other issues which are not on the table, which are not part of the discussion, we are going off course. Ultimately, whatever we say is not going to shape the reforms that are taking place. So any meaningful discussions, any meaningful contributions from you as African scholars, really you must look at those items that have been discussed, and then you look at the problem with them, and you say, this is how we would like things to work as African countries. And again, methodology is very important. I think you have seen methodology, which I didn't see in your papers. So methodology, your framework, that's what ties in your paper neatly together. You don't find yourself discussing about 20 issues in one paper, because again, we are looking at the depth. The moment we have too many issues, then you are discussing it at the superficial level. And assuming you want to send it out for publication, you're gonna get a rejection. So you want to go deep, right, into the subject matter. This is why for like Emma next to me here, I said, Emma, all these other issues you are referring to, quite important, quite useful, but pick one and get deep inside of it. And also the framework, the methodology, the philosophy, the literature behind. We want that to be very intense, okay? So that's really a take home for all of you, and especially those who are still writing their PhDs. I mean, you need to go deep, and you need to stay on course if your PhDs are going to be useful. Otherwise, it's going to be one of those that are going to gather dust, because right now, countries are focusing on specific issues, not these other ones. Maybe time will come once, because we are doing it piecemeal, all right? So right now, we are looking at the process, the court. So later on, when we have achieved this milestone, it may be the time will come for us to look at the substantive issues, and then you will contribute on how the substantive issues can be dealt with. Okay, so thank you to Martin, to Emma, to Caitlin. Your presentations were fascinating, and to our commentators, Prof. Van Aken and also Prof. Reinisch. So
let's have 1 minute. Just
okay. Oh, I forgot you.
Just one, but I'm not going to take.
Okay.
No problem. Okay. I would love to answer all of them, maybe two, because one's very quick. I remember some years ago, young PhD student, I was at a workshop with Mark Bungenberg, and I said expropriation is not a right. I think Mark wanted to throw me out of the room. I still haven't changed. I think I can convince. I know that it's a long conversation, but maybe over dinner. The distinction between what I was talking about and contributory negligence or contributory fault, you don't really know what to call it. I wrote a book on contributory fault. I called it contributory fault. I'm happy. About a month ago, an arbitral tribunal cited it. They just spelt my name incorrectly. So the difference is that contributory fault arises when the investor foresees the unlawful conduct of the state coming towards it, and it takes the risk. So for example, if the investor invests in Spain or any other country paying a subsidy, and the investor thinks, you know what, because of the political climate, that subsidy might disappear in the future, then it foresees the risk. And if the risk eventually materializes, the arbitral tribunal should say, all right, there has to be a reduction because you took the risk and it didn't pay off. What I was talking about here is actually there's no foresight on the part of the investor. I'm just saying in some situations in life, in this case, investment disputes, investors just have to accept there are going to be losses from what they are doing because the state changes the law, for example. And I'm trying to embed that idea into the calculation for compensation. Cut.
Thank you. So a round of applause to our presenters and commentators. So I hand over to Anna. Hey. Great.
It's at 6:45.
Okay, shall we get 5-minute comfort break?
We'll have a 5 minute.
Yeah.
May I suggest something? Is that tomorrow I'm starting with a keynote speech. I can do my 5 minutes introduction to the UNCITRAL days for Africa tomorrow morning when I'm doing my keynote speech.
Okay.
Rather than taking 5 minutes break, coming back, and me speaking 5 minutes, I'm happy to do that tomorrow morning.
Yeah, okay. I think that makes sense because then that gives people, we can go back to the hotel